All please rise. The Honorable, the Chief Justice of the Republic of the Philippines, the Senior Associate Justice, and the Associate Justices of the Supreme Court of the Philippines. Hear ye, hear ye, hear ye. All persons having business before the Honorable Supreme Court of the Philippines shall give their attention, for the court is now in session.
Please be seated.
Madam Clerk of Court, please call the case before us.
Good morning, Your Honors. This is a continuation of the oral arguments in GR number 257575, Melvin A. Baluyot, petitioner, versus Maria Fe C. Antonio Baluyot and Republic of the Philippines, respondents. Thank you, Your Honors.
Appearances, please.
Good morning, Your Honor. Same appearance as counsel for the petitioner. I'm Attorney Melvin De Castro Mane, Your Honor.
Good morning, Your Honors. Good morning to our distinguished amici. The Office of the Solicitor General respectfully re-enters its appearance for the respondent of the Republic of the Philippines. I'm Solicitor General Darlene Marie Berberabe. With me, Your Honors, are Assistant Solicitor General Marisa de la Cruz Galandines, ASG Mirna Agno Canuto, and ASG Sarah May Cruz. Other lawyers of the OSG are in the gallery to provide assistance whenever necessary. Thank you.
Thank you, Soljen. For the record, appearing this morning as Amici Curiae are Justice Adolfo S. Ascuna, retired, Attorney Elizabeth H. Aguiling Pangalanan, Attorney Melencio S. Santa Maria Jr., Attorney Maria Carolina T. Ligarda, Attorney Eliezer Ambatali, representing Dr. Claire Dennis S. Mapa. I will proceed with the interpellation. May I call on Justice Chapardi Mampao to proceed with this interpellation?
Thank you, Chief. May I ask the counsel for the petitioner to answer these questions? Good morning, Attorney Melvin De Castro.
Good morning, Justice.
You claim in your petition that equal protection clause is violated when former Filipino citizens are treated differently from foreign spouses under Article 26, Paragraph 2 of the Family Code. Is that correct?
Yes, Your Honor.
However, Article 15, Section 2 of the Constitution recognizes that the state has a compelling interest in protecting the inviolable institution of marriage. And in fact, the Constitution explicitly provides, quote, marriage as an inviolable institution is the foundation of the family and shall be protected by the state. Is that correct?
Yes, Your Honor.
How do you propose this court weigh or balance this compelling interest against the petitioner's right to remarry in light of the legislative policy against divorce between Filipino citizens?
Yes, Your Honor. Petitioner maintains are very much aware, Your Honor, that the state actually acquired great importance, especially to the marriage being an inviolable social institution. And as an aspect of marriage is the sacredness of the marriage, Your Honor. But the inviolability of marriage or as a social institution does not carry with it, or must carry with it, the acceptance of the fact that it must be based on justice and reason. In this particular case, Your Honor, the marriage has already been dissolved by virtue of foreign divorce acquired by the petitioner abroad. If to maintain that the marriage still exists under the Philippine law, Your Honor, it actually will result to the very absurdity that Article 26, Paragraph 2 try to avoid, Your Honor. That's why, with respect to the equal protection of law, Your Honor, if the petitioner, or in this case, or there's no substantial distinction between a person who able to obtain a former Filipino who obtained a foreign divorce abroad, because, Your Honor, whether the divorce were obtained before or after, the fact is not based rather on the substantial distinction. They're basically the same foreign national.
You argued that it is discriminatory to treat former Filipino citizens on the basis of whether the divorce was obtained before or after the naturalization. Is that correct?
Yes, Your Honor. Because the moment the Filipino or former Filipino become a foreign national, they actually sever their connection whatsoever to the Philippine law. As in the word, and therefore, to distinguish between the two of them, whether before or after acquiring foreign citizenship, would be unfair and constitute a violation because it's not based on the principle of reasonableness.
Is that not based on valid or substantial distinction, given that it is based on the legal capacity to act?
No, Your Honor. No, Your Honor. Considering that the moment, as I've said a while ago, Your Honor, with due respect, the moment that the Filipino acquired foreign nationality, it ceases or sever the vinculum juris that ties him to the Filipino. And the moment, and to distinguish between the two of them, before or after, the fact, before or after acquiring foreign citizenship is technically not based on substantial distinction.
How is it discriminatory if it is grounded in the party's personal law at the time the divorce is obtained? Are you aware of the provision of Article 15 of the Civil Code which enunciates the nationality principle? Can you recall the provision?
Yes,
Article 15.
Yes, Your Honor.
What does it say?
Bear with me, I do not able to memorize it.
Okay,
but nevertheless, if I may,
I'll state the law.
Yes, Your Honor.
Laws relating to family rights and duties, status, condition, and legal capacity of persons are binding upon citizens of the Philippines, even though living abroad. That is precisely the nationality principle.
Yes, Your Honor. But the thing is, that nationality principle apply only as long as the Filipino or the petitioner remains a Filipino. Because citizenship is not written in stone, Your Honor. It's a dynamic. The moment that the Filipino acquire foreign citizenship, it carries with it changes or transformation in its personal law, pursuant to the very Article 415, Paragraph 2 of the Civil Code, Your Honor. In this particular case, Your Honor, with due respect, to insist that a petitioner cannot have his marriage or foreign divorce recognized in the Philippines constitute the violation of that Article 15 tried to uphold, Your Honor, because there is a point in time wherein the nationality of the petitioner has already changed and transformed to foreign national, foreign citizenship, which is actually provided him with a new legal text basis upon which his foreign divorce is based or can be upheld.
It is undisputed that the petitioner is a dual citizen.
Yes, Your
So
Honor.
he still retains that Filipino citizenship.
Yes, Your Honor. I understand that he was a Filipino at the time when he obtained a foreign divorce and thereafter reacquired foreign Filipino citizenship pursuant to 1925. But we have to remember, Your Honor, this case is not, this is actually a case of petition for recognition. Would you bear with me, Your Honor? Because in a petition for recognition, as in this particular case, the issue is actually not just the act of the dissolving the marriage, Your Honor, but it's only recognition of the fact that the marriage was already dissolved under the foreign law. That is why, Your Honor, despite the fact that he was a Filipino citizen at the time he obtained the foreign divorce, his subsequent acquisition of foreigner has provided again with a legal basis for seeking this petition for recognition.
You invoke this basic statutory principle, rule, in Latin maxim, obelix non distinguet, nec nos distinguere divimus. What's the meaning of that?
Yes, when the law does not distinguish, we should not make a distinction, Your
Okay.
Honor.
However, your petition urges the court to read into Article 26, Paragraph 2 of the Family Code a distinction between a Filipino who obtains divorce and one who later on becomes a foreign national. Would you agree that this is precisely a distinction the law as written does not contemplate?
Yes, I believe, Your Honor, also the same stand. But we have to remember that in Obrasido in Manalo, this is actually the same dilemma this Honorable Court was confronted with. And through the tools of interpreting and constructing the law, they were able to justify a situation involving Filipino parties wherein originally was not allowed to have their marriage or foreign divorce recognized. This petitioner maintains that this is just an extension, an equitable extension of the principle laid down by an honorable court in Manalo and Abrasido, Your Honor.
When did your petitioner obtain divorce? When? October 18, 2010.
Octo, yes, Your Honor.
And he became American citizen when?
He became on February 20, 2019.
2019, after
Yes, Your
9
Honor.
years.
Yes, Your Honor.
And subsequently, more than a year, he applied for dual citizenship. So he obtained his dual citizenship on July 30,
2020.
2020, after a year. Okay, this is your theory on pages 6 to 7 of your petition, Amendment 16. You advance a theory or postulation that the accusation of American citizenship cures any defect in the divorce he obtained while still a Filipino.
No, Your Honor.
It's on Amendment 16 of your, it cures the defect.
Your Honor, technically...
Can you check pages 6
I
7 of your petition,
Oh.
specifically Amendment 16? That's the gist of your theory. It cures the defect.
Actually, as I've said, Your Honor.
So you are changing your theory?
No, Your Honor. Actually, when he changed his acquired American citizenship, and that transform, Your Honor, I stick on my answer that he transformed his personal law to that of American, which is under the American law, regards divorce as valid.
As dual citizen, he remains bound by the two legal systems, correct?
Yes, Your Honor.
Can the petitioner selectively invoke a foreign nationality when it is favorable to him?
At the first glance, that would be myself, that's also my impression, Your Honor. But the truth is that when the petitioner become or subsequently reacquired his foreign citizenship, actually, Your Honor, he just continue on with the journey of his evolution of his identity as an individual. When he acquired his Philippine citizenship by virtue of Republic Act number 9925, actually, it does not invalidate, Your Honor, what happened or the marriage or the foreign divorce he obtained while an American citizen.
Is it not contradictory to claim benefit from American citizenship while invoking his Filipino status in filing a petition before the court?
No, Your Honor, because it's actually anchored, is anchored on the fact of the application and interpretation of provisions in Republic Act 9925, which is as if did not lose his Filipino citizenship, which petitioner maintains does not invalidate. If he did not invalidate, it carries with him a dual citizenship, Your Honor. This is actually the reason why the Filipino having dual citizenship and OFW living and residing abroad are a dilemma they're confronted with. Because if the court or the honorable court would insist that by reacquiring his Filipino citizenship he would lose, no one would bother to go. Would not bother to acquire for a citizenship of reacquire Philippine citizenship because it invalidate, Your Honor, the divorce they already obtained abroad.
You mentioned the case of Republic versus Cipriano Bicedo III.
Yes, Your Honor.
So I assume that you know the ruling there. What's the ruling of the court?
In that particular ruling, wherein the court reiterated that that basically the ruling is that there must be a foreign national at the time of divorce. At least one of the parties, Your Honor, for someone to invoke petition for recognition of divorce, Your Honor, under Article 26, Paragraph 2.
Did the court liberally construe Article 26, Paragraph 2 of the Family Code in that case?
Yes, Your Honor. Yes, Your Honor. Because before that, the foreign citizenship, there must be at least at the time of celebration of the marriage. And in Obrecido, Your Honor, the law somehow relaxes its ruling by adopting.
What is the reckoning point there?
In that particular case, Your Honor, at the time the divorce was obtained in Obrecido.
Is the policy enunciated therein applicable to your case?
I'm not saying that directly, and I'm not directly because there's the difference in the facts of the case. But the petitioner maintains that the wisdom and justification in Obrecido, along with Manalo, is actually can be extended into this particular case by applications of purposive and liberal interpretation of law, given the fact that Article 26, Paragraph 2 is actually a remedial law.
Republic versus Orbicero III was promulgated on October 5, 2005. Volume 509, Philippine Reports 108. Okay, 106. Manalo, Republic versus Manalo, which initiated the same public policy, was promulgated when?
I'm not very good at on the date, Your Honor.
April
I think it's
24,
something
2018.
Yes. Oh.
Volume 831, Philippine Reports 33. Is the policy, public policy involved in these two cases, again, applicable to your case?
Yes, Your Honor. Petitioner maintains that this is applicable, Your Honor, because
Okay.
yes.
What is that public policy underlying the rulings in these two cases?
The avoidance of a situation wherein a party is regarded as marriage in the Philippines and divorce abroad, Your Honor. Avoidance of limping marriage.
To
Your Honor.
avoid the absurd situation where Filipino spouse remains married to an alien spouse who after obtaining a divorce is no longer married to the Philippines. That is exactly the statement of the Joint Committee that drafted the Family Code. And you are maintaining, postulating that that is applicable to your case?
Yes, Your Honor. Because if the recognition would be denied, Your Honor, the petitioner being both an American and American citizen, both American and Filipino citizen, will be regarded as married under divorced under the American law and married under the Philippine law.
Thank you, Attorney De La Cruz. May I ask the Solicitor General to answer the few questions?
Good morning, Your Honor.
Good morning, ma'am. On pages 28 to 29 of your memorandum, you argue that the non-recognition of the petitioner's divorce does not perpetuate injustice, given that the state's policy on absolute divorce applies to petitioner. Is that correct?
That is correct, Your Honor.
However, jurisprudence affirms that Article 26, Paragraph 2 of the Family Code embodies a public policy of its own. And let me reiterate what the Joint Committee that drafted the Family Code said about this. Quote, to avoid the absurd situation where a Filipino spouse remains married to an alien spouse who, after obtaining a divorce, is no longer married to the Filipino spouse, unquote. That is the public policy underlying in that jurisprudence.
That is correct, Your Honor.
It would appear that this may reflect two conflicting public policies. And in controversies involving Article 26, Paragraph 2 of the Family Code, it is the more specific policy that should prevail, in line with the judiciary's evolving liberal approach in interpreting and applying the law. Correct?
Correct, Your Honor. However, it is the view of the Republic that the Article 15 of the new Civil Code provides for the nationality principle or the choice of law principle. We follow the nationality principle, which goes from a very long history, from the Code of Napoleon in the 19th century in 1804, which heavily influenced the Spanish Code in 1889, and which in 1950, when the Commission adopted the Civil Code, consciously adopted the Article 9 of Spanish Code, which is practically the same provision. So which means that it carries with it the tradition of why nationality principle was adopted by the civil law countries as opposed to the common law countries showcased by England, which had a different history and different evolution. And for the Republic, Article 26 provides a narrow exception in recognition of the modern trend and in order to avoid the foreseen injustice. And Your Honor, what strikes us and which crystallizes the view of the Republic is that the very exact situation that we are discussing here has been the specific issue that was considered by the committee then, and that is what will be the rule if the involved individuals are both Filipino citizens and still it is the personal law. The nationality principle must still be observed, Your Honor. So Article 26 for us just provides a very narrow exception.
In light of the ruling of the court in Republic versus Orbisido, and subsequently the case of Republic versus Manalo, would you agree that the judiciary's evolving policy is to adopt a liberal approach in interpreting and applying Article 26, Paragraph 2 of the Family Code?
We note the progression or the evolution of the thought process of the Supreme Court, and we respect that in those spaces where there are gaps that the court considered as unforeseen, then the principle of equity, which goes again through a long history, equity is to apply or to look for a just solution for those gaps, which the general law might not have anticipated, but it is our position that this situation was actually anticipated, and the executive order, which has the status also of a legislative act, carries with it the wisdom of the provision that went into Article 26 and, of course, the Civil Code in Article 15.
In your view, would it be considered as judicial legislation if, in deciding to grant the reliefs sought by the petitioner, the court may simply modify the ruling in the case of Republic versus Orbisido III and adopts yet a liberal interpretation of Article 26, Paragraph 2 by enunciating that in order to apply, first, the reckoning point will be the party's citizenship at the time the divorce is sought to be recognized in the Philippines, rather than, as enunciated in Republic versus Orbisido, the party's citizenship at the time the divorce was obtained. Two, For purposes of this provision, a dual citizen can be considered as an alien spouse. What do you say? That's the possible modification of the Orbicido doctrine.
Your Honor, with regard to the judicial legislation, so the jurisprudence as it now stands, the reckoning or the reckoning threshold will be that the spouses are Filipino citizens at the time of divorce. Now, if we grant this, it is our humble and respectful position that it will be it will amount to judicial legislation. Again, because of looking at the text of Article 26, looking at the deliberations which brought to life the Article 26, paragraph 2. So it is our humble position that it will be going against the wisdom of that provision of law.
Invariably, you are telling us that it is not within the ambit of the power of the court to interpret the law.
Yes, Your Honor. Respectfully, we also are taking note that in recent cases, such as Gramatica and Ursua cases, where the court was also mindful of certain consequences or impact, most injustice have been addressed, but there could also be others which remain to be unaddressed. And if I may quote in Gramatica versus People, a 2025 case per Honorable Justice Inting, the court's duty is to give effect to the clear letter of the law, not to rewrite it to impose a penalty more suited to the moral outrage evoked by the facts. Any modification or enhancement of the prescribed penalties lies within the exclusive province of the legislature and not the judiciary. And also in Joseph versus Ursua, a 2025 case penned by Justice Joseph Lopez, the court also said that the court does not have the monopoly to assure the freedom and rights of homosexual couples with the political, moral, and cultural questions that surround the issue concerning the rights of same-sex couples. Political departments, especially the Congress, must be involved to quest for solutions which balance interests while maintaining fealty to fundamental freedoms, if I may.
Do you know that the court applied the Orbicida doctrine in 25 cases, the latest of which is the case of Republic versus Nang, 951 Iskra 785? Okay.
Yes, Your Honor. But
Then
not exactly
Republic versus Manalo has been applied by the court in 20 cases, the latest of which is the case of Anedo versus Republic, 959 Iskra 436. So it would appear that the court applied that public policy, so 25 plus 20 in 45 cases. So is my understanding of your view correct that the policy enunciated in Orbicido and Manalo is not applicable to the petition before this court?
They are applicable, Your Honor, and Republic versus Iyoy seems to be the one that is also closest because at that time, both were Filipinos at the time of divorce but naturalized after.
On the pages 44 to 47 of your memorandum, you stated therein that a dual citizen, by virtue of concurrently holding both foreign and Philippine citizenship must comply with the laws of both jurisdictions, correct?
Yes, Your Honor.
You even stated that Articles 11, 12, 13, 21, and 40 of the Family Code is applicable to a dual citizen on account of his or her continuing Filipino citizenship.
Yes, Your Honor.
Don't you perceive or discern any inconsistency in requiring dual citizen to comply with the procedural requirements laid down in those articles while at the same time recognizing the validity of a foreign divorce?
Your Honor, it is our position that based also, because of the RA 9225, we studied also the deliberations behind 9225, and it seems that the legislature was more focused on the political rights, political aspect of RA 9225, and not so much focused on the applicability of the personal law. Still and all, if we become consistent that the petitioner has or must observe the nationality law principle as well under Philippine law, then at the time that he obtained the divorce, he is also covered by the nationality principle, Your Honor.
Elsewise stated, why should we apply these procedural requirements under the Family Code while at the same time disregard the equally binding prohibition on absolute divorce under Philippine law?
Your Honor, the petition that the petitioner filed is recognition of foreign divorce. However, it is not a simple submission to the court of a foreign judgment because no sovereign is required to observe or respect a decision of a foreign court. So it will be subject to the evidentiary requirements, which it is also our position that the petitioner is deficient in submitting even the evidentiary requirements. So the first hurdle has not been satisfied even. And in the petition, so it goes also behind the whole framework and procedure that our country observes. So for example, the petition affects the status of the Filipino, and under Article 412 of the Civil Code, it has to undergo a judicial process of changing that status.
Thank you very much, Madam Solicitor.
Thank you very much, Your
May I
Honor.
ask Professor Elizabeth Aguiling Pangalangan to take the podium and answer these few questions based on your memorandum you submitted before this court.
Good morning, Your Honors.
Good morning, ma'am. On pages 20 to 21 of your memorandum, you pointed out that non-recognition of the petitioner's divorce, the recognition of the petitioner's divorce here may in effect give rise to this scenario, which the Joint Committee that drafted the Family Code intended to prevent, which is favoring wealthy Filipinos to secure divorces abroad. Is that correct?
Your Honor, I'm sorry, I don't have a copy of my own amicus
that's true.
brief.
It may be
but-
wrong, but that's what you have said there. You mentioned about that discussion of the Joint Committee that drafted Family
Yes, Your
Code.
Honor.
Let's avoid the situation where it may favor wealthy Filipino citizens who can
Yes,
afford
Your
to
Honor.
secure.
Yes, Your
divorces
Honor,
abroad.
because they will be the only ones who can go abroad, live there, and secure
You
a
quoted
foreign
that.
divorce. Your Honor.
Okay. Would you agree that, having said that, the same concern applies to Filipino citizens who have the means to acquire foreign citizenship and subsequently obtain a divorce?
Yes, Your Honor, they would be more or less the same people who can go abroad. Although now, Your Honor, with the migration pattern with the overseas Filipino workers, they too have tremendous opportunity to live and work abroad, and therefore they could also take advantage, I would say, of the opportunity to file a divorce there and have that recognized at least in the state where they are.
In
living
any
and-
case, given the court's ruling in Republic versus Orbecido, which upheld the application of Article 26, Paragraph 2 of the Family Code, even when both spouses were originally citizens and only one became a foreign national, could it be said that the potential abuse based on economic means is not the underlying consideration in interpreting and applying the provision?
That it is not a reason for not applying.
You
the-
mentioned about that possible abuse.
Yes, Your Honor. That the fact that this may be abused by some, Your Honor, I think should not be taken against those who have the opportunity to live and work abroad and get a foreign divorce, Your Honor. But I think, Your Honor, that this is just the effect of the fact that there is no law that allows divorce in the Philippines, which contradicts or which is incongruous with the lived reality of Filipinos, which is that many, a significant portion of our population work abroad and live there for long periods. So there is an incongruity, and that is where the tension arises, Your Honor.
Ma'am, you took the position in your memorandum, in fact, you advanced this approach or theory, most significant relationship
Yes, Your Honor.
approach, correct?
Yes, Your Honor. Yes, Your Honor.
Na-
The most.
And
sorry.
consistent with this, it's your postulation that we apply American law under that lex domicile, as
Yes,
the U.S. is considered as the adopted country of the petitioner and the place with which he is most closely connected.
Yes, Your Honor. Your Honor, in my amicus brief, I discussed at length the traditional approach, which will just apply the Philippine laws. That is in answer to the questions raised by the court about whether there is an extant provision in the family code that will allow this case to be decided a certain way, and also another question about the present state of law. But I was able to mention, Your Honor, that if the court uses a different approach, not a traditional approach, but one of the modern approaches to choice of law, then it could arrive at a different resolution, Your Honor. And one of these modern approaches is the most significant relationship approach, which does not apply the technically apply the law. It instead looks at the other factors to which a particular person or the case itself may be more closely connected, Your Honor. And one could be the domicile.
Would you agree that the core issue in the petitioner's petition is the recognition of divorce, not the grant of divorce?
Oh, yes, definitely, Your Honor. Thank you for that. This is merely a recognition of a foreign divorce, a recognition of a divorce already valid in another jurisdiction, and therefore, for me, this could call for a recharacterization of the case, not as an issue pertaining to recognition of divorce that will lead to the application of the nationality principle, but instead a question of recognition of a foreign judgment, which would yield a different result, Your Honor.
Would you agree that the legal system with most significant relationship with the issue here, which is the recognition of divorce, is the Philippine legal system?
The most significant relationship, Your Honor. I'm sorry, Your Honor, but I would consider the United States the place of the most significant relationship, Your Honor. In my amicus brief, I was unable to discuss this in full because, Your Honor, at that time, not all the facts were clear to us. In fact, it was only during the first oral argument that some important facts were elicited by the court, one of which, and which I would consider pivotal to my analysis, is the fact that Baluyot had already remarried. I recall that some of your honors asked, if he was indeed divorced and he considered himself divorced, why is it that when he applied for reacquisition of Filipino citizenship, he said that his civil status was married? And it was only during that oral argument where it was clear that indeed he was married, but to another person, Your Honor. And so for me, if this person had already remarried and continued to live abroad and work there, then he is most closely connected to that jurisdiction and not to the Philippines anymore, Your Honor.
Just to clarify the implications of this most significant relationship approach that you are espousing, is my understanding correct of your theory that if we apply the American law, lex domicili, the petitioner can remarry?
Yes, Your Honor, as in fact he has remarried, Your Honor. And the reason why he was able to remarry in the U.S. is because, according to U.S. law, his first marriage had already been terminated. And that anywhere in the U.S., because of the full faith and credit clause in the U.S. Constitution, a decision rendered by one of the 50 states will be recognized as a matter of general rule in all the other 49 states. And so this dual citizen, or even if the citizenship, the reacquisition of the Filipino citizen came later, as far as the U.S. is concerned, his marriage had already been terminated, and therefore he had the capacity to remarry.
What happens now to the divorce obtained by the petitioner, which is purportedly void under Philippine law? Would that be disregarded under the theory that you are espousing now, or disregard such divorce?
No, Your Honor. In fact, that foreign divorce is recognized by the U.S. courts, Your Honor. And therefore, I would submit, Your Honor, that since this is... what comes to my mind is the case of Fujiki versus Marinay, although that's not for divorce, but for recognition of a declaration of nullity issued by the Japanese courts, where the court held that the RTC was committed error in dismissing the case because that was not a case for nullity of marriage, but for recognition of a foreign judgment. So I would say that I see the analogy, Your Honor, that this is not a case for foreign divorce, but just a recognition of a foreign divorce, and which is already a judgment valid and legal in the place where it was obtained, Your Honor.
Thank you very much, ma'am. May
Thank
I
you, Your
call
Honor.
Justice Adolfo Ascuna to take the podium and answer these 2 or 3 questions based on your submission. Yes, sir.
Thank you very much, Your Honor.
Good morning, sir. Article 26, paragraph 2 itself is an exception to the Philippine prohibition on divorce when the court, in its 2 rulings, relaxed the application of the law. Sir, what public policy that may justify non-recognition of the petitioner's divorce, given that as dual citizen, he is for all intents and purposes considered as alien, and therefore he may be allowed to remarry?
Your Honors, I maintain that in view of the provisions of our civil code on nationality principle, the bedrock foundational rule is that Filipinos, even while abroad, are subject to their personal laws by Philippine law. And the only exception to that very strong public policy is that embodied in Article 26, paragraph 2 of the Family Code, which was designed to remedy an injustice where a person is no longer married to somebody, but still cannot remarry. So we provided in that provision a very special exception to the public policy of nationality principle, so that if one of the parties at the time of the marriage is a foreigner, and the foreigner subsequently obtains a valid divorce, allowing him or her to remarry, then the Filipino spouse is also allowed to remarry. That is the provision. It has been liberally interpreted in subsequent cases by this honorable court. For instance, in Manalo, it was the Filipino who obtained the divorce, not the foreigner. Supreme Court said in view of the equality between spouses, between women and men, it doesn't matter who gets the divorce as long as there was mixed marriage at the time of the marriage. One was a foreigner. And yet in, I think, Orbisido case, where the parties were both Filipinos at the time of the marriage, but at the time of the divorce, they were foreigners. Supreme Court said what matters is the time of the divorce. At the time of the divorce, if they are, one of them is a foreigner, then 26 paragraph 2 applies.
Sir, okay.
That is the situation, Your Honor. But in this particular case, at the time of the divorce, both were Filipinos. And so 26 paragraph 2 cannot apply. And exceptions are strictly construed while we try to give liberal interpretation to remedy an injustice. There is no injustice here because they were both Filipinos at the time of the divorce. And so the bedrock principle of nationality would apply to them. Of course, there's another view that this is not really a matter of marriage, but a matter of recognition of foreign judgment under private international law. And that applies a different public policy. So there are actually two conflicting public policies here. Our public policy that says that Filipinos must be governed as to their personal law by nationality principle, and the other public policy is that we are in an international world and we are bound by committee to recognize valid judgments of foreign courts. So prescinding from the nature of the case as a divorce, where personal relations laws are applicable, we view it as a private international law problem of recognition of foreign judgment and application of comity. And therefore, it's a choice between two conflicting public policies, Your Honor.
Sir, on page 7 of your submission, you expressed the view that the remedy of a Filipino citizen who obtained divorce prior to the accusation of foreign citizenship is to obtain another divorce with the foreign court.
My submission, Your Honors, is the principle of nationality prevails over recognition of foreign judgment because of the provision of the Constitution, which very clearly says that marriage is an inviolable social institution, and therefore the exceptions must be strictly applied and not to defeat the principle where it is clearly involved, where there are two Filipino citizens obtaining a divorce abroad. I believe that that would violate not only the nationality principle, but also the provision of the Constitution that the Filipino family, in the Filipino family, marriage is an inviolable social institution, Your Honors.
Sir, do you affirm that opinion you expressed in your submission on page 7, that the remedy of a Filipino citizen who obtained divorce prior to the accusation of American citizenship is to obtain another divorce after he acquired American citizenship? That's what you stated on your submission, to obtain another divorce after he subsequently acquired American citizenship. Do you confirm that? It's on your submission.
That's an excellent point, Your Honor. In this particular case, I look at the records. It would appear that the petitioner applied for American citizenship after the divorce.
Yes, yes. That's
After
why you
the
made
application was after, and the grant of foreign citizenship even much after. So even if we retroact the acquisition of foreign citizenship to the time of the application, it will not reach the time of the divorce. I would have agreed, perhaps, to a retroactivity as validating the divorce if the application antedated the divorce. But in this particular case, it was, I think, a year or more than a year that after the divorce was granted, that the petitioner applied for foreign citizenship. So in that case, even under interpretations of retroactivity, it will not save the divorce, in my mind, Your Honor.
So you don't advise the petitioner to obtain another divorce after he subsequently acquired American citizenship?
Yes, Your Honor, like in Orbicido case, because what matters, according to this honorable court, is the citizenship of the parties at the time of the divorce.
Is it your view that the petitioner's divorce should not be recognized here?
In this case, Your Honor, the only way...
Even if he is a dual citizen?
The dual citizenship makes it worse, Your Honor, because principle of dual citizenship is the party is still a Filipino and is subjected to both the foreign law and Philippine law in matters of validity of divorce and marriage. So it only brings back the nationality principle to the applicability of the situation, Your Honor.
Thank you very much, sir.
Thank you, Your Honor.
May I respectfully ask Dean Melencio Santa Maria take the podium and answer these, I think, two questions.
Good morning, Your Honors.
Good morning, Dean. The Philippines is bound by Article 16, Paragraph 1C of the Convention on the Elimination of All Discrimination Against Women, that's the CEDAW.
Yes, Your Honor.
And Article 23, you mentioned that, of the International Covenant on Civil and Political Rights, ICCPR.
Yes.
Both oblige states to ensure equality of rights between spouses at the dissolution of marriage.
That is correct, Your Honor.
Invariably, this committee principle is likewise embodied in the 1970 Hague Convention on the recognition of divorces and legal separations.
Okay, Your Honor.
Is the Philippines a party to that? Do you happen to know if...
Well, I am not aware that the Philippines is a party to that convention, Your Honor.
In any case, these international commitments arguably militate against leaving one spouse limping in marital status at the time of the foreign divorce decree. This is now my question. How do you reconcile these international obligations and commitments with the literal wording of Article 6, Section Paragraph 2 of the Family Code, which speaks of Filipino citizen and a foreigner?
You are talking about Article 26, Paragraph 2. Let us look at Article 26, Paragraph 2.
How do you reconcile these international commitments that we have just mentioned with the literal wording of Article 26, Paragraph 2 of the Family Code?
Article 26, Paragraph 2 does not provide a hidden, unexpressed public policy prohibiting divorce. As a matter of fact, no Philippine law prohibits divorce. That is a fact. We cannot divine any public policy prohibitive in its nature from the clear text of Article 26.2. When you look at the Family Code, Article 26.2 is located in the chapter of requisites of marriage. That is what it is all about. If a Filipino married marries a foreigner, there is an added requirement. The foreigner must be capacitated to marry in the law of the place of the tribunal which decreed it. That is all what it is. It does not prohibit absolute divorce. No law in the Philippines prohibits absolute divorce. So that if we are parties to international convention like the ICCPR, the United Nations Human Rights Convention, providing for equal rights in matters of dissolution, then we have to abide by it, pacta sunt servanda. Because our Constitution also provides the incorporation doctrine, the generally accepted principles of international law is part of the law of the land. And in that regard, Your Honor, Rule 39, Section 48 of the Rules of Court has been elevated from a procedural rule to a statutory status because in Mijares versus Rañada, it says that it is customary international law. And let me talk about, Your Honor, Article 15 of the Family Code, the nationality rule. It says family laws, rights, duties, legal capacity, condition shall be governed by the law of the Philippines wherever they are. Let us look very closely on Article 15. It does not prohibit a change of status. Article 15 merely defines the nature and attribute of the person's legal identity. We change status all the time. We file annulment case, nullity case. From married, we become single. An illegitimate child, the operative act is a valid marriage, we legitimate the child. A stranger child, we adopt the child, we make him legitimate. We change status naturally by death, from married to widow, and by law, by procedure. We see that in the family code. So that Article 15 does not really conflict with international law. It's not the gate that will prohibit or keep out the effects of international law, because Article 15, our nationality rule, merely defines the nature and attribute of your legal identity, but does not prohibit it. So therefore, Your Honor, the synergy is very clear. The synergy is very clear, Your Honor. Rule 39 is the input. The journey starts abroad. You go to a foreign court, get a judgment, which is the fact, and then you bring it to the Philippines via Rule 39, the input. And the output is your Article 15. Once we recognize the person as already single, we protect him. We say to the whole world, he is single. So that's the relationship, Your Honor. There is a synergy. Let us already get out from that notion that Article 15 is a static wall that keeps out a fact, a judgment. Rule 39 says, judgment shall be presumptive evidence of a right. The judgment is a presumptive evidence of a right. And that right is the right to be single. The Filipino does not come to the Philippines to seek divorce. The Filipino comes here to have his singleness acknowledged. And therefore, the next question is, Your Honor, what is it against public policy? Your Honor, it is not against public policy. So there is the synergy, Your Honor. It does not really conflict with each other.
If we adopt a purposive, treaty-consistent reading that benefits Mr. Baloyot, do you know of a legal principle or precept that would keep the courts, Philippine courts, from effectively recognizing every divorce between two Filipino citizens, which would preempt the Congress prerogative to legislate absolute divorce?
First of all, Your Honor, there is no need for a treaty. My humble opinion, Your Honor, is that Rule 39, Section 38 is enough. Is enough, Your Honor. Simply because, Your Honor, even this court said that the burden of proof to show that it is against public policy is for the person who asserts it. And so that therefore the default mode should be one of recognition. And so that therefore the one who should file the petition for recognition or petition to discard that recognition is on the assailant, Your Honor. Is on the assailant. It's just a matter, Your Honor, of... That's why, Your Honor, I see this case as a pivotal, jurisprudential, landmark case, a potential one, because it can change the paradigm. Instead of the person who got the divorce seeking a petition for recognition of judgment, then let's just follow the ordinary rules. The default mode is to recognize that judgment and for the other party to say it is against public policy. Just what happened in the Nang case, Your Honor. A divorce obtained by mere letter in Japan, submitted to this court, and this court said there is no proof to show that it is against public policy. So the burden shifts.
And in that case, the court made mention these two cases, Republic versus Orbicedo and Republic versus Malalo. That was cited also there.
Yes, Your Honor, but I feel that Nang went one step forward. Because there is no law in the Philippines. There is no law in the Philippines allowing divorce by a letter of agreement. And yet this honorable court said it is not, there is no showing that it is against public policy. We admit it. And so that therefore, there is no need. Rule 49 is enough, especially so when it only talks about not an identity of law, but the effects of a foreign judgment. Are the effects of that foreign judgment, do they collide with the fundamental norms in Philippine law? It does not, Your Honor.
Thank you very much, Dean. May I call
Thank you.
Dean Maria Lisa Rosario Lopez.
Good morning, Your Honors.
Good morning, Dean. Article 2, Section 2 of the Constitution enjoins state to adopt the generally accepted principles of international law as part of the law of the land.
Yes, Your Honor.
That is precisely the incorporation theory, as opposed to, that's the other theory that is adopted, transformation theory. Mm-hmm. Okay, in my previous question, we mentioned about those international covenants, Article 16, Paragraph 1C of the Convention of the Elimination of All Forms of Discrimination against Women, and then the International Article 23 on the International Covenant on Civil and Political Rights. In this light, if we decline to recognize petitioners' divorce solely because they are parties that resulted because they were Filipino citizens at the time of the dissolution of marriage, we depart from the committee-based norm and create a limping marriage, which is inconsistent with the predictability that international law seeks to guarantee. My question is there any specific doctrinal justification that allows Philippine courts to withhold recognition of the petitioner's divorce without violating the Constitution's incorporation of the generally accepted principles of international law, or without undermining reciprocity for Philippine decrees abroad?
Your Honor, if I can recall, in my memorandum, I am requesting that petitioner should prove that at the time that he became a naturalized American citizen, American law recognized the decree of divorce issued to him. And I had the chance to talk to the counsel for petitioner because I was able to see the certificate of naturalization as an American citizen, and it says they are married. And I thought that that status referred to the first marriage. But then I was corrected, and he said that he is already married to the second wife. And having said that, looking at the ruling in the case of Republic versus Orbecido, so since when he acquired American nationality, we have no option but to apply to him the American law under the nationality theory. The only problem that we are faced right now, unlike in the case of Orbecido, the decision on the divorce was obtained when he was already an American citizen. In the case of Baluyot, the decree of divorce was issued prior to the acquisition of a new nationality. So what is important for us is to find out if indeed American government recognized the decree of divorce that was issued to him before he became an American national. And since based on the certificate of his American nationality, it indeed recognized, that's where comity now applies. We have to respect it. The problem, after acquiring this American nationality, he reacquired Filipino nationality. And at this point, I think we have to admit that our Dual Citizenship Act is not firm regarding the reacquisition of civil rights. Because in my position, it is not simply about an issue on divorce or marriage, but it also applies to other civil rights, just like what happened in the case of Aznar versus Christensen, an issue about inheritance. So probably it's best to refer back this Dual Citizenship Act to Congress for it to more or less amend the law and make it clear what happens if in case here is a Filipino national acquiring a foreign nationality and again reacquiring Filipino nationality, and there is a conflict when it comes to civil rights.
Dean, do we recognize foreign divorce that is valid and effective in the issuing country?
Based on the cases decided by the Honorable Supreme Court, I can say yes. But that is in consonance with the intention of the framers of the Family Code under the second paragraph of Article 26. Because it's very clear, I think it was only last minute that with the approval of the former President Cory Aquino that they decided to insert that provision. but subject to the condition that it should be a mixed marriage between a foreigner and a Filipino national. However, of course, we cannot overlook the case of Republic versus Orbisido, but in my humble opinion, even if that case was not decided or did not reach the Supreme Court, applying now the nationality theory under Article 15, when Orbisido became an American citizen when the decree of divorce was issued, we have no choice. We have to respect his new national law, which is American law. And if in American law, divorce is accepted, we have no right not to recognize it.
Thank you very much, Dean. My last two questions
Thank you very much.
are addressed to Professor Katrina Ligarda, please.
Good morning, Your Honors.
Good morning, ma'am. Is citizenship divisible? Is citizenship divisible?
Nowadays, I think so, Your Honor.
By-
So many Filipinos have become dual by buying golden visas in Spain and Portugal. I think they can become dual.
By divisible, we mean that in the case of a dual citizen, can we apply concurrently different sets of personal laws?
This is what I tell my students, Your Honor. I tell them that a Filipino who has become another citizenship cannot choose for himself what is beneficial to him under one law and prejudicial against him under the other law. That is what I say. So I think that if there is dual citizenship, the dual citizen should decide which citizen he intends to live, which citizenship he will intend to pursue.
In other words, he cannot selectively invoke the favorable rights afforded by one nationality over the other.
In my opinion, Your Honor.
Now let me demystify this scenario. If a dual citizen secured a valid divorce decree, as in this case, is he legally considered as a single under the American law while remains married under the Philippine law?
Yes, Your Honor, he's single. That is his status under all laws other than the Philippines.
My last question now is, does dual citizenship restrict or expand rights on marital status? Will it expand or restrict rights on marital status?
Only in the sense that the foreign citizen can now obtain a valid foreign divorce decree.
So it may work to restrict in what sense? On the other hand, it may work to expand in what sense?
In the sense that a foreign citizen can no longer accept by succession or as allowed by the Constitution, own land in this country, for example. Therefore, he might fall under the restrictions which the court has given under all the decisions where the foreign spouse cannot own land and therefore cannot claim any absolute community or conjugal property rights.
Thank you very much, ma'am.
Thank you, Your
Chief,
Honor.
that ends my interpolation. Thank you so much.
Thank you, Justice Limampao. May we ask Justice Monetsi to proceed with her interpellation?
Thank you, Chief. With your permission, may I call on the counsel for the petitioner, please?
Good morning, Your Honor.
Yes, good morning. Counsel, my first question is about Article 26, the second paragraph. So the marriage referred to there is supposed to be between a Filipino citizen and a foreigner, correct?
Yes, Your Honor.
And the same article speaks of the same spouses, a Filipino and a foreigner, who obtain a divorce abroad upon the alien spouse's initiative, correct?
Yes, Your Honor.
Okay. So, if it was the Filipino spouse who went abroad to obtain that divorce, the court has said what under those circumstances?
If we're going to take it literally, in literal interpretation of provision, then it is technically not allowed, Your Honor. But if with the advent of Republic versus Manalo, Your Honor, it has already been allowed.
Okay, but in Republic versus Manalo, the circumstance was that there was a Filipino spouse and an alien spouse.
Yes, Your Honor.
Right? Okay, thank you. So, of course, the rationale for the rule is to place the Filipino spouse on equal footing because it would be absurd to have the Filipino spouse considered still married to somebody who is already single and may have already remarried.
Yes, Your Honor.
Okay. Now, do you see a gap in the law?
Yes, Your Honor.
Okay. And what is that gap that you see?
It is that it doesn't provide a solution, or it does not cover or contemplate the situation wherein the petitioner is right now, Your Honor. Wherein he divorced his Filipino spouse while still a Filipino. Divorced while he's still a Filipino, but only after divorcing, which is after 9 or 10 years, that he acquired foreign nationality, which is American citizenship.
Okay, so that is the gap that you see in the law.
Yes, Your
So
Honor.
to remedy that gap, we need to amend the law, right?
That is the, with due respect, Your Honor, that is the easiest way of doing it. But these are
Oh, there's another way to
yes, Your
amend the
Honor.
law? Is there any other way?
Yes, Your Honor.
Oh, what
with due
is that
respect, Your Honor, is to adopt the liberal and purposive interpretation of law.
Judicial legislation, you mean?
No, Your Honor.
Oh.
But not judicial legislation, but rather than applying the principle adopted by an honorable court in the cases of Abrasido and Manalo.
Correct. So the Supreme Court will render a decision in your case in favor of your client, amending the law or changing what the law says?
No, Your Honor.
Yes? Yes or no?
No, Your Honor.
Yes. Now, in your client's case, was he a foreigner when he obtained the divorce?
No,
in
Your Honor.
California in 2010?
No, Your Honor.
No, he was a Filipino.
Yes, Your Honor.
Okay. In fact, he got his citizenship, his U.S. citizenship in 2019 only, 9 years after. Your client petitioned for recognition of the divorce decree in 2021 only, 2 years after he became a U.S. citizen.
Yes, Your Honor.
What was his reason for seeking recognition?
Um,
Well, earlier, you did tell us that it was because he wants to have a wedding or marriage conducted in the Philippines with his second wife, correct?
Yes, Your Honor.
So that's his reason.
That is a primary reason, Your Honor.
Yes,
but
that's
then
his
also,
reason.
Yes, Your Honor.
For filing, right?
Yes, Your Honor.
Okay. So that was his reason also for reacquiring Philippine citizenship?
I do believe, Your Honor.
Okay, so that's his reason for reacquiring Philippine citizenship. Okay. So your client married in the U.S. on November 8, 2010. That was just like a month or 2 months after he obtained the divorce, right?
Yes, Your Honor.
So he was still a Filipino when he remarried in the U.S.
Yes, Your Honor.
Okay. So if not for the fact that he wants to have a wedding here in the Philippines, he would not have filed this petition for recognition, right?
Your Honor, strictly speaking, yes, Your Honor. But
Okay.
it seems that the petitioner...
I'm okay with
Okay.
strictly speaking. Okay, and then on April 28, 2026, on pages 10 to 11 of the TSN, you said that the recognition of the foreign divorce recognizes only the effect of the foreign divorce on the civil status of the parties.
Yes, Your Honor.
You remember saying that?
Yes, Your Honor.
Okay. So, what do you mean by that? Only recognizes only the effect on the civil status, that he has become single? Is that what you're referring to?
No, I'm referring to the fact that, juridical fact that he already, as American citizen, which is which he subsequently acquired after obtaining divorce in the United States, it capacitates him to remarry or to conduct into a marriage, Your Honor, which allowed him to marry in the first place as an American citizen. Your
Okay,
Honor.
so if we grant the recognition, you are saying that we are effectively recognizing the validity of the divorce.
Yes, Your Honor. Because, as I said, with due respect, Your Honor, the petitioner maintains that this acquisition need not be at the very moment, or rather, his acquisition of foreign citizenship need not necessarily be at the very moment of the divorce, Your Honor.
Okay.
It could be after, just as in the particular case, where he obtained it as a Filipino and thereafter acquired foreign citizenship.
Okay, so of course you're aware that Rule 39 is just a procedural rule, right?
Yes, Your Honor.
The recognition of the foreign divorce, even if it's a foreign divorce judgment, will not entail an examination of the validity of that divorce.
Yes, Your Honor. But,
Yes.
Yes, Your Honor.
And it is actually just for the court in a case for recognition to study the existence of the foreign judgment, right? If it exists, and also if it was rendered in accordance with the foreign law.
Yes, Your Honor.
Okay.
The petitioner actually maintains that as initiated or discussed by one of the amici, Your Honor, that this is just a petition, with your respect, this is a petition for recognition, and that is basically the purpose, wherein what the petitioner seeks for the enforcement of the right or the divorce it obtained, which is already valid in the United States, which under Article 39 is actually basically highly enforceable.
So we are, by recognizing, if we grant the petition, if we recognize the foreign divorce, here we are giving effect to more than just a recognition that it exists and that it has been, and that the marriage has been declared, or the marriage has been dissolved by the California court.
Yes,
It goes
Your Honor.
beyond that. It goes beyond that.
In a way, yes, Your Honor.
Or in what way?
In a way that there will be no confusion, Your Honor.
Oh yes, now
yes,
you are
Your Honor.
confusing me.
I'm sorry. In the same way that, Your Honor, that there will be a consistency in his civil status, Your Honor.
A consistency.
Consistency in civil status, because, Your Honor, if the petition is particularly be denied, Your Honor, the absurd situation, which is actually trying to be prevented with Article
I wasn't
36, Your
speaking
Honor.
about denying it. I was speaking about granting it. That was why my question was phrased that way. This is a procedural rule, right?
Yes, Your Honor.
So you just want us to recognize this foreign divorce, correct?
Yes, Your Honor.
And under Rule 39, all that happens in a recognition of a foreign judgment is that the court declares the existence of the foreign judgment and declares that it was rendered in accordance with the foreign law.
Yes, Your Honor.
Yes. Yes.
Yes, Your Honor.
Okay, so we are clear on that?
Yes, Your Honor.
Okay, good. Okay, so earlier when Justice Dimaampao was interpellating you, you said these statements. First, you said that the moment the individual acquires foreign citizenship, they automatically sever their ties to the Philippines. You said that earlier.
Yes,
I
ma'am.
wrote it down. And then this one as well. The nationality principle applies only for so long as one remains Filipino, but the petitioner is already a U.S. citizen, which provided him with legal basis for a divorce. You also said that.
Yes, Your Honor.
Okay. So just to end with you, you argue that your client became a U.S. citizen, and so he became entitled to all benefits of a U.S. citizen. And so you argue that his divorce was validly obtained.
Yes, Your Honor.
Okay. Then you further argue that because your client reacquired Philippine citizenship, he became entitled to all the benefits of a Filipino citizen. And so you also further argue that he should not be discriminated against by interpreting Article 26 against him because he's also a Filipino, right?
Yes, Your Honor.
Okay. And so your client wants to be a U.S. citizen when it benefits him, and he also wants to be a Filipino citizen when it benefits him, right? That's what you're asking us to consider.
No, Your Honor.
No?
No, Your
It's
Honor.
okay.
Because
It's okay.
okay.
I don't need a reason. Thank you, Attorney. May I now call on the Solicitor General, please? Good morning.
Good morning, Your Honor.
Yes, Madam Solicitor General. If this court declines to recognize the divorce in this case, what damage or prejudice would be occasioned to the petitioner?
Well, he will have a different status here in the Philippines and different status in the U.S., Your Honor.
But Madam Solicitor, he is also a Filipino citizen. He's a dual citizen, isn't he?
I was referring to being single,
Yeah.
Your Honor. So, although, if I may say, it is of his own doing, that he will be in that predicament because he obtained the divorce while being a Filipino citizen and being covered by the nationality principle, Your Honor.
Okay, so his problem will be that here in the Philippines, he cannot marry.
Yes, Your Honor.
Okay, but for all intents and purposes, he can do whatever he wants everywhere else.
Yes, Your Honor.
Okay. So is that a denial of his rights as a Filipino being a dual citizen?
We do not think so, Your Honor. It is our view that based on the legal framework that we have now, actually the question is why, if he considers himself as a U.S. citizen, why is he actually asking this court to recognize his foreign divorce here in the Philippines? That's actually our practical question, Your Honor.
Okay. Is there any remedy or relief remaining for him in case we deny this petition?
Your Honor, we are looking, because in the last oral argument, we were also asked that question and I wasn't prepared. We are looking at filing another petition perhaps for declaration of nullity, although there is jurisprudence because they already filed a petition for declaration of nullity, but based on a different ground, which is lack of authority of the solemnizing officer. The petitioner might consider asking the court to review if there are grounds for petition for nullity under Article 36, Your Honor. I know I'm not the counsel for the petitioner, but that could be presented to the court for this court's consideration, Your Honor.
All right. My last question to you is every foreign judgment that is valid were rendered necessarily entitled to recognition in the Philippines?
No, Your Honor. Definitely not, Your Honor.
What would be the exception?
Article 17, Your Honor, of the new Civil Code, prohibitive laws concerning persons, their acts or property, and those which have for their object public order, public policy, good custom shall not be rendered ineffective by laws or judgments promulgated or by determinations or conventions agreed upon in a foreign country, Your Honor.
Okay. Do you agree that there is a public policy that is violated in cases of this sort?
Yes, Your Honor.
And what is that public policy?
Public policy that that divorce is not allowed in the present framework, present legal framework, Your Honor. We agree that there is no express prohibition, but all of the actions of the legislature, which is primarily designated as the one that defines the public policy and has not acted on at least 13 divorce bills, that is an affirmation of the position that is being taken by our political branches. We have reverted to a relative divorce under the legal framework of legal separation, psychological incapacity under Article 36, but as to absolute divorce, there are clear actions on the part of the political branches to not allow a mechanism for such, Your Honor.
Okay. And Madam Solicitor General, what about our laws on adultery, bigamy, concubinage? What are there? Are they also considerations in the determination of the public policy behind this?
Yes, Your Honor. So the public policy is against absolute divorce, Your Honor, and that our legal framework has allowed for relative divorce, identifying specific grounds that may be invoked by Filipino citizens, Your Honor.
Okay. Thank you very much.
Thank you, Your Honor.
May we now call on Professor Legarda?
Good morning, Your Honors.
Good morning. Professor Legarda, in 2010, after Baluyot, who was then a Filipino, got a divorce, what was his civil status in the U.S.?
Still a Filipino.
Okay, but he was already single.
As far as the U.S. was concerned,
Yes.
but still a Filipino.
Correct. Because is my understanding correct that you can file for divorce in the U.S. as long as you're a resident,
Yes.
even if you're not a citizen?
Yes, Your Honor.
Okay. And so in the Philippines, when that happened, what was his status?
Well,
After he obtained the divorce, what
Well, when
was his
the-
status here?
based on the decisions of the Supreme Court, he's still married to his first wife.
Okay. And then in 2019, when he was naturalized, when he became a naturalized U.S. citizen, what was his civil status? Did he become automatically
No. American?
Yes. Yeah, well, he
Yes, he
became an
became-
American, but what was his status, civil status in the Philippines?
In the Philippines, Your Honor, he would still be considered married because the divorce decree had not yet been recognized.
Okay.
And that is why, Your Honor, never mind, I won't say it anymore.
No,
Continue.
go ahead. Say it.
The right person to have filed this, Your Honor, is actually the Philippine wife,
Okay.
according to the Supreme Court case of Corpus versus Santo Tomas.
Okay. So in 2020, he became a dual citizen. So what was his civil status in the Philippines when he reacquired Philippine citizenship?
Well, he's divorced in the U.S. because of the American law, but because it had not yet been recognized, he would still be a Filipino because of the Supreme Court decisions which say that if he remarried here, he would be open to bigamy in the Philippines.
Okay. So, was the recognition, or will the recognition of the divorce, the California divorce, make his divorce from his first wife now effective and therefore make him single here in the Philippines?
In my opinion, yes, Your Honor.
Okay. Will that also have the effect of the second marriage in the United States recognized here?
No, Your Honor, because I read the minutes of the oral arguments last time, and it looks like he married the second time when they were both still Filipinos.
Correct. So no. That's paragraph 1 of Article
Yes.
26. Okay.
Yes.
All right. So now let's go to a different point. So Article 26 was of course enacted to place the Filipino spouse on equal footing because we view the Filipino spouse as the disadvantaged spouse.
Yes.
Right? But in this case, under these circumstances, it is the spouse who has the advantage of foreign citizenship who's bringing this suit before us for recognition. That would mean that we are no longer fulfilling the rationale for Article 26 if we favor the petition.
In the case of Corpus, Your Honor, the Supreme Court remanded to allow recognition of the foreign divorce because the foreign spouse, Corpus, who was a former Filipino, included his first wife in the petition, the Filipino wife. So the Supreme Court said, matter of housekeeping, yes, but the reason why we should at least allow this is because the Filipino wife was included in the petition.
Correct. So, but here, the Filipino spouse is a non-entity because she has not joined the petition. And we also know that the prior petition for declaration of nullity was denied, it was dismissed. Okay, so if the Filipino spouse, unlike Corpus, is not part of this proceeding, would the court have any basis, legal basis, to apply the prior rulings? Yes.
Your Honor, my understanding is the petition includes the Filipino spouse.
Here?
Yes, Your Honor. Yes, Your Honor.
She's a petitioner?
She's a respondent, Your Honor.
Right, but she's not a petitioner.
In Corpus too, she was a respondent, Your Honor.
But in Corpus, the
The
court remanded it, right?
Remanded.
Yes. Okay. So the court did not immediately grant the petition, right?
Yes, but very nice, the court rulings there, Your Honor.
Well,
Added
yes.
to jurisprudence.
Okay. So, I will ask you the same question I asked the Solicitor General. Is every foreign judgment that is valid where rendered necessarily entitled to recognition in the Philippines?
No, Your Honor. In fact, in the case of Rower versus Rodriguez, the Supreme Court said that the Philippine courts are not bound by the dispositions made in that foreign judgment. And in that foreign judgment of Rower, the custody of the children were entrusted to the German spouse, and they had a problem, obviously, back in the Philippines. And the lower court said, I don't have to follow the dispositions made there. Went up to the Supreme Court, and the Supreme Court agreed.
Exactly. Because Rule 39 only says that in recognition of a foreign judgment,
It's just the judgment.
and also it's just evidence of a presumptive right,
Yes,
correct?
yes.
And so a foreign divorce decree that says more than just that the
Divorce.
marriage is severed, for example, adjudicates property rights, custody, even support, that is not going to be considered as enforceable if it violates any of our laws.
Yes, and public policy, Your Honor, is for the child.
Yes.
And this was a Filipino child involved
Okay.
in Rower versus Rodriguez.
Okay. And so, along that line, if a foreign, like a recognition of a foreign judgment which upholds, let's say, a same-sex marriage is brought before our courts, what should be the fate of that?
Well, if the foreign judgment is to recognize a divorce of same-sex marriage, can be granted under Fujiki versus Marinay, because right now same-sex marriage is not allowed in our rules because Falsis, unfortunately, was the wrong person to bring it. Okay, but
Okay, so but it will not be it will,
otherwise, Your Honor, it probably won't be granted.
yes, because of the,
Because of public policy, by analogy, Fujiki versus
and also because
Marinay.
of the wording of the text of our law, our present
And
law.
because the text of Article 2.
Yes, in the same manner, a child marriage also.
Yes, Your
Okay.
Honor.
So if brought before us for a recognition, then it will suffer the same fate.
Yes, because it's void under our rules.
Okay, thank you very much.
Thank you, Your Honors.
Okay, my last questions will be for Dean Santa Maria.
Yes, Your Honor.
Yes, good morning. In the April 28 oral arguments, you stated that Rule 39 independently authorizes recognition of foreign divorce judgments.
Yes, Your Honor.
Okay. And then if Article 26 is the specific substantive law governing when foreign divorce is recognized in the Philippines, why should that procedural mechanism, the one in Rule 39, enlarge the substantive rights under Article 26?
Well, because, Your Honor, Rule 39, Section 49 is not diminished by the provisions of Article 26(2). First, Your Honor, because of Mijares versus Rañada, this procedural rule was elevated to a statutory norm because that decision said that petitions for recognition of foreign judgment has attained prevalent state practice and opinio juris sive necessitatis, which are the two elements of customary international law. And as we all know, Your Honor, the sources of international law are treaties, conventions, first; second, customary international law; third, general principles of international law; and third, statements of well-renowned treatises. And so that therefore, and there is no hierarchy in that, according to the Nicaragua case. And so that therefore, Your Honor, if that is the case, then our Constitution follows the incorporation doctrine that the generally accepted principles of international law is part of the law of the land. So I would even suggest that the petition for recognition of foreign judgment has been constitutionalized. It has become a constitutional right because it's now integrated as part of the law of the land. Or at the very least, it has attained a statutory status. So that is why, Your Honor, in effect, Article 26(2) has become supererogatory. It is superfluous because we do not need that anymore. It is by Rule 39, Section 48, that is enough. Remember, Your Honor, Rule 39, Section 48, we are not amending any local law. We are not importing any law. We are not repealing any law. We are accepting a judgment, a fact, which, as you said, is evidence of a presumptive right. And according to the Fujiki case, the default mode must be to accept, except if it is against public policy. So what I am advocating now is, what is the public policy now? Should we, if public policy, as I have said, is to be frozen in time, in its first articulation in 1939 in the Sicat case, and in 1964 in the Tenchabes case, disallowing recognition, then we live in a society that no longer exist, Your Honor.
Yes.
Because public policy for me, Your Honor, must be gauged from the constitutional and legal developments, from the shifting of our societal norms, and from medical and scientific developments. Your Honor, times have changed. If we are to be fixated by the old rules, this petition will be denied. So that therefore, Your Honor, this is a pivotal historical case, as I believe, because it can change the paradigm. We have to look at what is public policy today.
Okay. So you do accept that this Rule 39 mechanism is subject also to the limitation of public policy?
That is correct, Your Honor. If we look at the architecture of Rule 39, specifically, the exceptions deals with the integrity of the foreign decision.
Yes.
So we have no notice, we have fraud, we have mistake of law,
Yeah.
mistake of fact. And then we add jurisprudentially against public policy and morals. So if you talk about morals, we have already decisions defining what morality is in Philippine law. It must be public, it must be secular. And so that therefore the question is, if a Filipino is to marry a foreigner and to have a divorce, it's moral. But if a Filipino marries a Filipino and gets a divorce, it is immoral. Where is the substantial distinction, Your Honor? There is none. That is why it is against the equal protection of the law. There is no substantial distinction in its practical sense, in its emotional sense, in its psychological sense, and its legal sense. Absolutely none. In its practical sense, Your Honor, before annulity of marriage and a divorce, before they could marry, they first have to get a court order. Exactly the same. The nature of the freedom is the same. The emotional content before filing the case, most likely the same. A desperate spouse, an anguished life, just the same. And third, just like in the Baluyot case, Your Honor, if you look at the decision in the Baluyot case, the effects are the termination of the marriage, visitorial rights, custodial rights, and the dissolution of property. That is not, they are not, those do not collide, even with Philippine law. And so that therefore the Rule 39 is very explicit. The effects of a judgment, that is what we are looking for.
Okay, so Dean, you are telling us that the recognition of the foreign divorce will be subject to an examination of public policy. Now, who determines public policy?
Your Honor, that has already been decided by the Supreme Court. The Supreme Court will decide public policy. No. The legislator creates public policy. The Supreme Court identifies an already created public policy. And so that therefore, how should the Supreme Court do that? You have to look at the development in constitutional and legal law. You have to look at the shifting norms of conduct. You have to look at our experience. No, I'm just going to cite, Your Honor, the Supreme Court, when it said that the determination, when we determine public policy, first we have to look at the Constitution. And second, we have to look at the law. And if it's not in the Constitution and in the law, then we have to decide for yourself whether it is injurious to society. And that is where you look at the landscape of constitutional legal law. And in our Constitution, Your Honor, as held in the Manalo case, there is no absolute prohibition for divorce. And our family code explicitly repealed the article in the civil code on indissolubility of marriage. Total repeal, Your Honor. And that will show us, Your Honor, where we're going. And then we have the personal Muslim law where we allow 7 types of divorce. And then we have Article 26(2). So that therefore, Your Honor, we see that the norms are changing. We cannot live by way of a norm that no longer exists, Your Honor. We have to change.
Of course, Dean, we're your statements are rooted in the fact that you're looking at it from the viewpoint of divorce.
Yes, Your Honor.
Okay? But the other side of that is the marriage. Okay? And we have the Constitution where it is declared a compelling state interest to preserve the inviolability of marriage.
Yes, Your
and
Honor.
also the family as the basic social institution.
Let me explain.
That is a declared compelling state interest. And of course, we know that the passage of the family code is based on the same policy. Based on the same policy.
Your Honor, may I just explain
Yes,
that?
yes, go ahead.
You know, I will start by saying, let me just drink first.
Go ahead.
Be perfect, therefore, as your heavenly Father is perfect. That is Matthew 5:48. Then love your neighbor as you love yourself. That was the command. Be perfect, therefore, as your heavenly Father is perfect. Within the context of faith and life, this verse serves as a profound aspiration, a lofty objective of the soul, rather than a literal command. Jesus understood that human perfection is unrealizable in a world defined by fallibility. Thus the true command, the actional duty for the living is to love thy neighbor as you love yourself. This distinction is echoed, Your Honor, in the Holy Quran, which reminds us, and I hope I'm correct, Justice, our religion is the coloring of Allah. And who is better than Allah in coloring? And we are worshippers of Him. And do good as Allah has been good to you. Allah does not charge a soul except within its capacity. Both spiritual traditions recognize that while we must strive for the highest ideals, our laws and duties must remain rooted in human capacity and mercy. Let me go to our framers of the Constitution. The framers of our constitutions were builders of our society. They understood that words must be interpreted in the light of human experience, an experience that recognized the inherent unpredictability of life, filled with joy and misery. The framers knew that marriage is a human institution, susceptible to the vagaries of life. It is not a perfectly heavenly enterprise, immune to problems. And our framers, intelligent and transcendent as they are, were humble enough to know that they cannot mandate the unrealizable. And because of this, and their belief of the importance of marriage, I believe they frame such importance the best way they can, not as an edict, but as a goal to achieve, a constitutional aspiration for everybody to pursue, followed by a command, and shall be protected by law. And that law is the family code and the rules of court. And when we study these documents, Your Honor, we find out that inviolability should not mean untouchability, but should mean protection from arbitrary interference by the state and by the parties, Your Honor. To understand this more carefully, Your Honor, I have an analogy. My analogy is a basket full of fruit. In this metaphor, Your Honor, the basket represents the institution itself, the enduring social structure that the state is sworn to protect, the marriage as an institution. The individual matrimonial union are the different fruits within that basket. Inviolability refers to the status and survival of the basket in society, ensuring it is never replaced by another arrangement. In any harvest, the preservation and usefulness of the basket require the timely elimination of the rotten. When a union ceases to be a source of joy and become one of misery or hardship or an immuration, it is no longer a living part of that basket. To force a decaying union to remain bound to the healthy ones is not an act of protection in that basket. It is an act of institutional deterioration. Just as one decaying fruit can spread contamination, the legal insistence on maintaining defunct contracts devalues the institution.
Okay.
That's the analogy, Your Honor. And besides, Your Honor, if we disallow recognition of foreign divorce of two Filipinos, the question is, did we save their marriage? We did not. We did not save their marriage. And instead, we will invite bigamy, concubinage, adultery, illegitimacy, so that the other side, so that in disallowing, it is more, Your Honor, deleterious to society. Inviolability, Your Honor, is not meant by the Constitution to be a lifelong entanglement in a union that has already ceased to exist in all its functional sense. And that is why we have Rule 49, a fact, a judgment, termination of marriage. That's all what it is. Then we look at the effects. Then that's it. We allow it.
Okay, thank you, Dean Santa Maria. I will stop there on that spiritual note, Chief Justice. It's already lunchtime.
Okay. In view of the fact that it's 12 o'clock, we will suspend the session to resume at 1:30. Session is suspended.
All right. Please remain standing while the Chief Justice, the Senior Associate Justice, and the Associate Justices leave the session hall. Sinabi na. Dalawa lang yung coffee. Tapos sige. Yung all please rise. The Honorable, the Chief Justice of the Republic of the Philippines, the Senior Associate Justice, and the Associate Justices of the Supreme Court of the Philippines. Hear ye, hear ye, hear ye. All persons having business before the Honorable Supreme Court of the Philippines shall give their attention, for the court is now in session.
Please be seated.
Session resumes. May we call on Justice Amy Lazaro Javier to proceed with her interpellation?
Thank you, Chief Justice. May I have Attorney Mane, please? Thank you. Good afternoon, Attorney Mane. Just a few
Good afternoon,
clarificatory questions.
Yes, Your Honor.
When did the petitioner and the respondent get married?
They got married on March 14, 2000.
Yes.
Your Honor.
So when did the petitioner emigrate to the U.S.?
I'm not very particular with the specific date, Your Honor, but it must be sometime in between 2008 to 2009.
So that, can you clarify this with your client?
Yes, Your Honor.
Yes.
Mhm.
When he actually emigrated to the U.S.
Yes, Your Honor.
Yes. So, when did they have children? Does he have children with his first wife?
Yes, Your Honor. They have 2 children, Your Honor.
How old are the children?
The first one, Melina Marie, the daughter, was born in 1998. And the second child happens to be a son. He's June 25, 1999.
So,
There's a 1-year difference.
they bore children before they got married.
Yes, Your Honor. They already got 2 children.
So the children now are of age?
Yes, Your Honor.
They're both
There's
adults.
already 25, 26, Your Honor.
They live in the Philippines.
Yes, Your Honor, with the mother.
With the mother.
With the
The
mother.
mother never went to the U.S.
No, Your Honor.
Yes. So, when did he obtain a divorce decree from his wife?
October 18, 2010, Your Honor.
2010, 10
yes, Your
years
Honor. 10
after
years.
they got married.
Yes, Your Honor.
Yes. So, when did he remarry?
He remarried just technically almost more than a month after obtaining on November 8, 2010, Your Honor.
Is this the same woman he is married with as we speak?
Yes, Your Honor.
So, the same wife
Yes.
since
yes,
November 8, 2010
Yes,
up to
Your
this time.
yes, Your Honor.
And the wife is also American?
Rather to be clear on that, Your Honor, at the time they got married, the wife was still a Filipina.
Oh.
Yes, she's working as a nurse. Okay. But just 2 days after the wedding, or they got married, the second wife became an American citizen.
All right. They have children also?
Yes, Your Honor. Yes, Your Honor. Two, Your Honor. In fact, Your Honor, they have two children. The first one was born on December 19, 2011. And then the second one was October 16, 2013.
Did he give support to his children in the Philippines after he left for the U.S.?
I understand. When I confronted about that, Your Honor, before that, Your Honor, actually there was an attempt on the part of the petitioner, Your Honor, to have the marriage declare a nullity.
Yes.
Before he went to the United States, he filed a petition for.
So he filed a nullity of marriage
under Article
before he
36.
left for the U.S.
Yes, Your Honor.
Yes. So
And
what happened to that?
It was denied. Your Honor.
Because
Lack of merit, Your Honor.
lack of
Merit, Your Honor.
lack of merit
for
means
failure to establish the allegation in his petition. For the record, Your Honor, I'm not the counsel.
you
for
were
petition.
also the counsel.
Not the counsel.
That's why it was dismissed. Is that your point? Maybe
No, I'm not saying,
it would have had a different outcome if
No.
you were already the lawyer.
No, I'm not. I'm just wanting to make this clear, Your Honor.
All right. So, lack of evidence, perhaps.
Yes, Your Honor.
What court render it?
It was RTC Branch 89 in Quezon City, Your Honor.
Yes, and you
the-
just accepted it. Did you appeal?
No, Your Honor. It was already. I came into picture.
No, not you, the lawyer.
I don't know what happened there, Your Honor.
So
I
it
just have
seems
to
that,
rely-
but there are no records of appeal.
As far as I know, no, none, Your
Yes.
Honor. I was shown with a copy of certificate of finality.
Is there res judicata in declaration of nullity of marriage?
Vis-a-vis this particular petition, Your
Yes.
Honor. I don't believe there is, considering that it's based on different cause of action.
All right. The cause of action was
The first one is for the declaration of their marriage to be based on Article 36, and this one, on the other hand,
no,
is...
no. I'm not talking about this one. I am talking about the nullity of marriage case on ground of psychological incapacity.
Yeah, sure.
Is there res judicata
Yes.
in cases under 36?
Yes, I do believe, yes, Your Honor. I humbly believe.
What is your authority?
No,
Do
Your-
you have any reference, or can you cite any jurisprudence or provision of law that there is res judicata when it comes to nullity of marriage under 36?
Your Honor, by itself, Your Honor, the moment that the decision of a particular, in a case, whether it is granted or denied, has attained finality.
In fact, there is no res judicata. That case can be refiled, especially when the reason for the denial was lack of merit because there was no sufficient evidence to support the grant of the nullity of marriage. So with that said, do you believe me? You must believe me.
Okay.
Otherwise,
If it is an imposition, I have to.
no,
agree.
it's not an. You ought to know that.
Yes, thank you very much for the information.
It's not an imposition. That is a bad word.
I'm sorry, Your Honor.
Yes. Don't say that. I'm not imposing. No, I'm just stating a fact.
Yes,
That
thank
is the principle. So,
I'm not aware of that. Thank you
yes,
for the
now you are.
information.
All right. So, if the petitioner can actually refile a case for nullity of marriage, is that an adequate remedy that will leave him? Is that an adequate remedy that will provide him relief
Yes,
from
Your-
his first marriage?
Yes, Your Honor, if it would not constitute a res judicata.
Oh, you still
it would
don't
not-
believe
No,
me?
Your Honor. Yes, Your Honor. Because it will relieve him because he can still file another petition for
Correct.
declaration.
So it
nullity
is
of
not
marriage.
correct to say that the petitioner here has no remedy to turn to after the court. I'm not saying how the court will act, but should the court deny this petition, the petitioner is left with a remedy that is plain, speedy, and adequate in the ordinary course of law, especially with the Tan Andal versus Tan case. Actually, that is a question.
Okay. Yeah. Yes, Your Honor. I agree with you.
Yes,
Yeah,
you agree. So we can dismiss this case and you can still seek relief that is just and equitable and plain, speedy, and adequate.
Yes, Your Honor.
Yes.
But, yes, Your Honor.
Very good. Now, your client, the petitioner, was a Filipino citizen when he secured a divorce decree from his wife, who was also, and is up to now, a Filipino. What is the status of that marriage at that time it was secured?
At the time it was secured, Your Honor, it is valid.
Don't say
Valid, Your Honor.
Valid.
Yes, Your Honor.
Yes. At that time they got married. The
Yes.
marriage was valid. But at the time the divorce decree was obtained, was it a valid decree under Philippine laws, considering that they were both Filipino citizens?
No, Your Honor, because of Article 15, Paragraph 2 of the Civil Code.
Correct. So,
The nationality principle.
a void judgment is void from the very beginning, ab initio. Okay. Is there any jurisprudence or provision of law that allows a void judgment to become valid?
None, Your Honor, as far as I know.
So a void divorce decree is void till the end of time.
Yes, Your Honor.
Yes. All right. The divorce decree in the U.S. that was obtained by petitioner, is that res judicata?
Sorry, Your Honor.
Okay. The divorce decree that was obtained by the petitioner from the U.S., is that res judicata?
Res judicata as to the first marriage, Your Honor? Res judicata.
as to the parties.
As to the parties, Your Honor.
Yes.
Given the fact that both parties at the time were still Filipino, yes, Your Honor.
No, no. The divorce decree, is that as against the first wife, is that res judicata in the United States?
In the U.S., no, Your Honor.
No.
No, Your Honor.
It's not res judicata.
Yes, because it is in the United States.
Yes, so does it mean that he can refile an application for divorce?
Refile, Your
Yes,
Honor.
yes.
Your Honor.
Is it barred by prior judgment, or he can just move to another state and secure another divorce decree now that he has already become an American citizen?
Your Honor, I already advised my client about the possibility of securing another divorce in another state, Your Honor, so that we can avoid.
So that is another remedy
yes, another
available.
remedy, yes, Your Honor. But
So-
it's more of for economic reason. It becomes a little bit difficult on the part of the petitioner.
We're not talking about that. We're
Yes, Your Honor.
talking of the right
Possibility.
thing to do and the availability of remedies to your client. And the remedies are plain, speedy, and maybe not as expensive as the nullity of marriage in the Philippines. Obtaining a divorce from another state in the United States is an available remedy that will finally settle the status of your client. Do you agree?
Yes, Your Honor.
Yes,
Yes, Your Honor.
very well.
Actually, that's the reason why I
Yes.
advise him to do that, if possible.
You advise him to do that. What did he say?
As I've said,
Is he
Your Honor,
accepting your advice?
unfortunately, because of economic difficulty, because he has a job and everything is settled in California, getting a residence in other state is almost very extremely difficult, if not.
He cannot obtain it from Vegas. What happens there stays there. All right. That's all. Thank you,
Thank
Attorney
you.
Mann.
Thank you very much, Your Honor.
Thank you, Chief Justice. I'm done.
May I call on Justice Alfredo Benjamin Caguiwa to proceed with his interpretation?
Thank you, Chief. Can I call the Solgen?
Good afternoon, Your Honor.
Good afternoon. You're familiar with SPJI?
Yes, Your Honor.
One of the objectives under the SPJI is improving access to justice for the public or the end users. Am I correct in presuming that the OSG, as the People's Tribune, has the same or shares the same objective for the public?
Yes, Your Honor.
Access to justice is a very broad concept. But will you agree with me that this includes making it easier for the public to navigate the legal processes and eliminating unnecessary roadblocks?
Yes, Your Honor.
Now, both the court and the OSG are actors in our justice system. And although we have different roles, would you agree that both the Supreme Court and the OSG should strive to interpret the law in a way that promotes access to justice?
Yes, Your Honor.
Can I ask Attorney Mane to just take the podium for a while?
Good afternoon, Your Honor.
Good afternoon. I understand from your client's submissions that Mr. Baluyot's reason for filing the petition for recognition of the foreign divorce is so that he and his current wife may be able to marry in the Philippines through a religious ceremony before relatives and friends. Is that correct?
Yes, Your Honor, I affirm that.
And is my understanding correct that he filed the petition because he believes that he is required to first obtain judicial recognition of the foreign divorce before he can hold a religious ceremony in the Philippines?
Not religious, not necessarily religious, any marriage, Your Honor.
But that's in your manifestation.
If that be the case, yes, Your Honor.
You did.
Any marriage, Your Honor, any marriage, before he can contracted marriage in the Philippines.
No, let's be clear. Is it a religious ceremony or a civil ceremony?
Your Honor, as I remember during the last hearing when I asked what kind of marriage, Your Honor, as far as I remember, it is a Christian wedding. Yes, Christian wedding, not necessarily Catholic. Okay.
Yes, but it's
Yes,
religious,
Your Honor, it's,
not
yes,
civil.
religious wedding, Your Honor.
So it's religious,
Religious
right?
wedding, yes, Your
Okay.
Honor.
In his compliance dated October 27, 2025, Mr. Baluyot said that he was advised by his fellow Filipinos in America that he needed to first obtain a judicial recognition of his foreign divorce, even if he wanted only to hold a religious ceremony so that he can avoid charges of bigamy. Counsel, did you tell him whether this was a correct legal requirement?
Your Honor, I honestly believe yes, because because when you say religious, he perhaps presumed that he still have to go through with the process of securing marriage licenses, Your Honor.
So you confirmed as a lawyer yung opinion ng mga kaibigan niya sa States?
Yes,
Ganun
Your
ba?
Honor.
Okay. As counsel for Mr. Baluyot, did you confirm if this advice is correct with any government agency, such as the local civil registrar, the PSA, or even the DFA? Did you confirm?
I asked a friend of mine in the local civil register in Laguna, Your Honor, about before I handle this matter, and then and even my friends from the judiciary, especially in the second level, about the possibility of just, and they all concur that there's still a need that the foreign divorce be still recognized.
Even if your client only wanted a religious ceremony?
Yes, Your Honor, because it's still yes, Your Honor.
Are you familiar with what a civil religious ceremony is?
Yes, Your Honor. The one that being conducted usually is very typical at the Catholic wedding.
Does it produce civil effects in the Philippines?
Yes, Your Honor.
Really?
Yes, yeah, because with due respect, Your Honor, I make it a presumption, or my answer is based on the presumption that that before they push through with that, they still have to secure marriage licenses, Your Honor. And that's why it would be
For a religious
registration.
ceremony, you actually have to secure a marriage license?
Yes, Your Honor.
Okay. All right, Attorney Manny, thank you.
Yes.
You can sit down. Before I proceed with my other questions, I would like to make it of record and emphasize that in answering, I hope the parties in the amici would keep in mind that when the court resolves the present case involving Mr. Baluyot, it is also presented the opportunity to unravel prevailing jurisprudence that began in 2005 with the case of Orbicido and in the Corpus case of 2010, which, in my opinion, does not have basis in substantive law, and make way for probably a new framework that is consistent with the court's mandate of improving access to justice. So on that note, Madam Solicitor General, let me begin with the Civil Code. The Civil Code before the Family Code took effect. Under the Civil Code, the provisions concerning the requirements of an application for a marriage license are found in Articles 59, 60, and 61. They're being flashed now in the screen. Inviting your attention to Article 59, item number 5. It speaks of a divorce. Do you agree with me that that item refers to a foreigner seeking to marry in the Philippines?
Yes, Your Honor.
Wanting to marry in the Philippines, whether to a Filipino or to another foreigner, he is required under Article 59.5 to disclose in the application for a marriage license whether he was divorced, and if yes, how and when, correct?
Yes, Your Honor.
And according to Article 61, such foreigner must submit to the local civil registrar the decree of the divorce court, right?
Yes, Your Honor.
And according to Article 66, can you flash Article 66? Such foreigner must also obtain and submit a certificate of legal capacity to contract marriage issued by his diplomatic or consular office, correct?
Correct, Your Honor.
And these requirements are substantially the same requirements under the Family Code, correct?
Yes, Your Honor.
At this juncture, can I ask the representative of the Civil Registrar General to come to the podium?
Good afternoon, Your Honors.
Good afternoon. So let's begin with the situation. American A gets married to Filipina B under the Civil Code in 1975. They get married, and in 1985, still under the Civil Code, American A divorces Filipino B in California. American A then wants to get married to Filipina C in 1986, still under the Civil Code, and he applies for a marriage license. American A fills up the application form, submits the required divorce decree, and the certificate of legal capacity to marry. In this example, under the Civil Code, can you confirm that he will in fact be given a marriage license?
Yes, I confirm, Your Honor.
So to be clear, American A will not be required to have his foreign divorce decree in California first judicially recognized by a Philippine court, correct?
Yes, Your Honor.
Again, to be clear, in filling up the application form, American A will not be required to prove his national law or the law of the place where the divorce was obtained to determine if the divorce was valid, correct?
Yes, Your Honor.
In fact, all that is required is a certificate of legal capacity to contract marriage to be issued by the United States Embassy in the Philippines, correct?
That's correct, Your Honor.
And if I'm correct, for US citizens, all they need to execute is an affidavit in lieu of a certificate of legal capacity to contract marriage, because the United States apparently does not maintain a database of marriages, correct?
That's also correct, Your Honor.
Okay. Can you pull up, according to Article 64, it says there, upon being advised of any alleged impediment to the marriage, the local civil registrar shall forthwith make an investigation examining persons under oath. If he is convinced that there is an impediment, it shall be his duty to withhold the marriage license. My question to you is this: is this provision under the Civil Code regime triggered if the local civil registrar had knowledge of American A's marriage to B?
If the application for marriage license happened before the family code, the effectivity of family code, Your Honor, yes.
It will not be triggered.
The application will be actually denied.
It will be denied? Because?
Because of certain impediments.
He's an American.
Yes, Your Honor. Because the American already presented a divorce decree. Yeah, it will not be triggered, Your Honor.
It will not be triggered.
Yeah.
Thank
I
you.
withdraw my.
Okay. Let's now talk about Filipina B. Remember my situation?
Yes, Your Honor.
She wants to get married to a Filipino in 1986, still under the Civil Code. Okay? Do you agree with me that she will not be issued a marriage license?
Yes, Your Honor.
And that is because the Civil Code does not recognize divorce as a mode of terminating a Filipino's marriage, correct?
That's correct, Your Honor.
And that is precisely why the Family Code, Article 26, Paragraph 2, was enacted. And that is to address the situation where Filipina B is left in limbo while American A is now free to marry Filipina C, correct?
Yes, Your Honor.
Now, with my example, Solicitor General, would you agree with me that securing a marriage license by a divorcee under the Civil Code was very much straightforward?
Yes, Your Honor.
There was no need to file any petition in court to recognize the foreign decree of divorce, correct?
Yes, Your Honor.
Okay. Let's now go to the Family Code, which became effective on August 3, 1988. Can you flash Article 26? Can you just stay there, Mr. while I propound questions to the Solicitor General? Okay. Article 26(2) of the Family Code was enacted precisely to address that anomalous situation where the Filipino is still considered married to a foreigner, even if the foreigner is already free to get married to someone else, correct?
Correct, Your Honor.
And yet, this solution is not really a solution, right? By that I mean, under current jurisprudence, that Filipino is given the burden of having to file a petition in a Philippine court, incurring all the costs attendant to a trial, in order to have the decree of divorce obtained by the foreigner abroad judicially recognized here in the Philippines, correct?
Correct, Your Honor.
And when we talk about costs, it is not just about hiring a lawyer. The costs include those related to obtaining the foreign law, proving it, obtaining an English translation when the divorce decree is written in a language other than English. Those are the costs attendant to all this, correct?
Correct, Your Honor.
And this is brought about by our rules on evidence, particularly Rule 132, Section 24 and 25. Can you flash that on the screen? Which require an official publication or a copy attested to by the officer having legal custody of the record, correct?
Correct, Your Honor.
And so that everybody here, including the members of the bank, so that everybody is aware, you and I are members of a technical working group, correct?
Correct, Your Honor.
On divorce decrees.
Yes, Your Honor.
That's a sub-technical working group on the concerns of OFWs regarding the recognition of foreign divorce decrees, correct?
Correct, Your Honor.
In fact, the DFA is also a member of the TWG. And we are in the process of signing a memorandum of agreement with the DFA. You're aware of that, right?
Yes, Your Honor.
The court, through the TWG, requested if the DFA can provide foreign laws on marriage and divorce. However, the DFA's representative, on several Zoom meetings that we had, after collecting the comments from 40 foreign posts, raised several issues, correct?
I am now made aware, Your Honor.
They're there on the screen. I think your ASGs can confirm that these are the concerns raised by the DFA. First, and I'm stating all of this for the record, the difficulty in compiling the foreign law on marriage and divorce, especially in countries where family law is scattered in several jurisdictions. B, there is no designated office in the foreign counterpart specifically authorized to certify statutory laws. In many countries, there is no official custodian of the law since it is just published online. And C, the Foreign Ministry denies the request of the DFA for copies of the law or its English translations because it is not part of their official functions to supply official copies of the law or its translations. So my question to you, Madam Solicitor General, if the DFA is having so much difficulty in compiling the foreign laws on marriage, what more for an ordinary Filipino? How can he prove the law?
Your Honor, I agree that there have been a lot of challenges expressed also and shared in the TWG. And it is my humble submission that the court can look at the rules on evidence and also address such challenges if they can be addressed also by the court.
Something that the court can do in this case.
Yes, Your Honor.
Thank you. And when we talk of the cost, Solicitor General, we're not talking just in terms of money, right?
Yes, Your Honor.
We're talking about time.
Yes, Your Honor.
The time needed to just collect all of these requirements, correct?
Correct, Your Honor.
And in fact, in your experience as Solgen, or in the experience of the office, there are cases that have dragged on for years, precisely because of the difficulty in obtaining these requirements, correct?
Correct, Your Honor.
Okay. You agreed with me earlier that Article 26.2 of the Family Code was meant to liberate the Filipina woman from the situation of being married to someone who is no longer married to her. And yet, it seems to me that that liberation is really good on paper only, meaning the Filipino spouse is not truly liberated unless and until the foreign divorce decree is first judicially recognized by a Philippine court, correct?
Yes, Your Honor.
And the foreign spouse, who is not required to have their foreign divorce decree first judicially recognized, their liberation from the marriage is total, complete, and absolute, correct?
Yes, Your Honor.
There is an unfairness here, would you agree?
There is a lot of unfairness, Your Honor, in many other laws that confront us, and it is my humble submission that all of the considerations that we are discussing here would be best threshed out also in the legislative proceedings where they could, for example, have a
Let me cut you there. It can be addressed also by proper interpretations by the Supreme Court of applicable law, correct?
Yes, Your Honor, within the framework of what is allowed by the law.
Of course. Did I say anything otherwise?
Just, no, Your Honor.
In fact, this is talking about access to justice. This is an unequal access to justice, correct?
Yes, Your Honor.
Okay. Let me go back to the Civil Registrar General. I want to do a deeper dive, all right? Under the Family Code, do you agree that for foreigners who wish to marry in the Philippines, they only need to submit a certificate of legal capacity together with the application to obtain a marriage license?
Yes, Your Honor.
That's in Article 21 of the Family Code.
Yes, Your Honor.
Okay. Can you please flash on the screen a template for this affidavit? That is all that the applicant has to fill up, correct?
Yes, Your Honor. This is for, Your Honor, this is for U.S. citizens.
Yes,
Your Honor.
yes. Mr. Baluyot is a U.S. citizen. That's why I chose U.S. citizens. Now, can you please flash a duly accomplished sample affidavit in lieu of certificate of legal capacity to marry? I have redacted the names. That is all that needs to be submitted, correct?
Yes, Your Honor.
Okay. So going back to my earlier example of American A, when he applies for a marriage license to marry Filipina C, this time under the Family Code or post-1988, and he submits this specific affidavit on screen, which shows that he was previously married and that his marriage was dissolved by divorce, will you require that he submit a copy of the foreign divorce?
That's not required under the current rules.
Really?
Your Honor.
Article 13, Family Code.
Yeah, yes.
He is
Sorry, Your Honor.
required to submit the judicial decree of the absolute divorce.
Yes, Your Honor. Yeah. Together with the legal capacity, but it's.
But that's
for
an
the-
affidavit.
yes.
That's that one, correct? So
Yes.
the decree of divorce and that affidavit, would a photocopy suffice?
Our local civil registrars requires at least a certified true copy.
So we're talking apostille.
It's either apostille or
A certified true copy.
certified true copy by the embassy.
Okay. Aside from the affidavit in lieu of certificate of legal capacity, U.S. citizen, and the apostilled or certified true copy of the foreign divorce decree, no other documents, requirements for American A to obtain a marriage license and remarry in the Philippines, correct?
Actually, the applicant needs to show also a proof of identification bearing also the nationality, his nationality.
All right, para lang alam natin tao talaga siya.
Yes, and also the nationality of that person.
With respect to the foreign divorce decree submitted to the local civil registrar, what does the LCR do with that? Is it registered? Or if so, in what book?
Yes, Your Honor, it's registered. It's contained in a separate registry book for marriage licenses.
Is there a term for that book?
It's usually a book for marriage licenses. So the local civil registrar, Your Honor, maintains a book for every application.
So the foreign divorce decree is filed with a book containing marriage licenses?
I'm sorry, Your Honor. The decree of the divorce.
Yes. It's kept by the LCR.
It's kept by the LCR.
Is it registered in a book? Or is it just kept?
It's just kept.
It's just kept.
It's just kept because it's an attachment to the marriage license.
So there is no separate book for this?
There is a separate book for the judicial declaration of recognition of foreign divorce, Your Honor, but it is a different book from the book of the marriage license.
Okay. To your knowledge, is this the same rule under the civil code? What the local civil registrar does today, is it the same?
The application for marriage license, Your Honor.
No, with respect to the divorce decree, what the LCR does, is it the same before, during the time of the civil code?
Actually, Your Honor, the practice of registering or recognizing or registering the foreign divorce changed when the Orbisido case came about.
So it was not by any statutory law, because under the civil code, there was none, right?
Yes, Your Honor.
In fact, this book that you call Judicial Declaration of Decrees book did not exist under the civil code.
Yes, Your Honor.
All right. So going back to our situation of American A having divorced Filipina B, wanting to marry Filipina C, and is now applying for a marriage license, what else will you require before you process American A's application for marriage license?
This is
under the family code.
Okay, under the family code, Your Honor, for the American spouse, he should present the affidavit in lieu of capacity.
Yes.
A valid identification.
Yes.
If he has undergone divorce, then attach the
decree of divorce. Aside from that,
and then the application and all the required. There are some requirements like seminars that's being undergone in the local civil registry offices, Your Honor.
But this time, let me clarify this. This time, since he is applying under the family code, his marriage with Filipina B is registered with the PSA.
Yes,
correct?
Your Honor.
So paano yun?
Your Honor, for a foreigner, there is no requirement of a certificate of no marriage.
So therefore, you will issue him a marriage license.
Yes, Your Honor.
Okay. There is no need for a judicial recognition by a Philippine court of his foreign divorce with Filipina B?
Yes, Your Honor, primarily because A is already a
An
US
American.
citizen. Yes.
All right. Can you bring up PSA Memo Circular Number 2025-06? Look at the language of this one. It says, a petition for recognition of a foreign court decree judgment order must be filed before the proper local court in the Philippines before it can be registered and be given any legal effect. Now, the full text of that PSA memo, Circular 2025-06, and I'm showing it on the screen. That's the relevant part of the circular, which appears to be the basis for the circular. Can you confirm that?
Yes, sir.
Okay. Based on my reading of that flashed on the screen, this circular is based solely on the basis of the case of Corpus versus Santo Tomas and the Solicitor General. Am I correct?
Yes, Your Honor.
All right. But prior to even this memorandum circular, there was another one, right? Can you flash that? NSO Memorandum Circular Number 2007-2008, which says that judgments of a foreign court are not self-executing and must therefore be recognized by a Philippine court. As seen on the screen, the NSO circular cites as its only basis the case of Republic versus Orbicido. Do you confirm that?
Yes, Your Honor.
All right. So do you agree with me that the only basis for this judicial recognition requirement in both memo circulars is not any law, but only two cases?
Yes, Your Honor. Actually, 3 cases, Your Honor.
What's the third one?
The RBC decided Garcia versus Resio.
Yeah. All of them are division cases, correct? They are. Okay, so let's talk about those cases. All right? Okay. Let's go first to the case of Orbicido. In gist, the facts are Orbicido and Villanueva, both Filipinos, and they got married. Villanueva, the girl, later goes to the States, becomes naturalized as a U.S. citizen, and later on, as a naturalized U.S. citizen, obtains a foreign divorce and marries a certain Stanley. So Orbicido, left here in the Philippines, filed with the trial court a petition for authority to remarry, invoking Article 26(2) of the Family Code. The trial court granted the petition. The OSG appealed to the Supreme Court. The main issue that confronted the court was whether Article 26(2) applies to Orbicido. And in its ruling, the court treated the petition as one for declaratory relief, ruling that Orbicido should be allowed to remarry under Article 26(2). However, since he failed to prove the divorce decree, the naturalization of his wife, and the fact that she had already remarried an American, the court said there is no factual basis to support his petition. Hence, it granted the OSG's petition and set aside the RTC decision. Is my understanding of the facts similar to yours?
Yes, Your Honor.
Solgen?
Yes, Your Honor.
All right. Okay, let me segue a bit. In Orbicido, the OSG filed an MR of the RTC decision and then appealed its denial to the Supreme Court. As well, in foreign divorce cases that have reached the Supreme Court, the Republic is often a party in these types of cases represented by the OSG. And there are many cases where the lower courts have granted the recognition, but the OSG, always the OSG, appeals on the ground that the elements of 26(2) Family Code have not been proven. And so I am curious. I am curious as to the Republic's or the OSG's role in foreign divorce cases. I want to know if there is any substantive law that requires OSG to participate in these types of cases.
We made a study, Your Honor, with regard to the origin of why, in such cases, the OSG is being asked to enter its appearance and to file its comment. I believe that there was an order or a resolution from the Supreme Court, and based on the mandate of the OSG as the counsel for the Republic, so that the Republic will have will be given the opportunity to present its position.
When you talk about mandate, you're talking about Section 35 of the Administrative Code of 1987. Am I correct?
Yes, Your Honor.
Okay, can we flash that on the screen? Are we able to flash that on the screen? Tell me which paragraph here authorizes you to enter your appearance, if we're talking mandate.
The mandate, Your Honor, to represent the position of the Republic, not expressly, Your Honor.
It's
and I
not,
believe,
sorry, Section 35 enumerates all the situations where you are mandated to represent. I'm trying to figure out where you fall, and I don't find any. Unless you can tell me now.
in paragraph 1, Your Honor.
Where?
In paragraph 1, can we go back to the... In paragraph 1, I was reading, Your Honor, all other courts or tribunals in all civil actions and special proceedings in which the government or any officer thereof in his official capacity is a party, and the Solgen is the representative or the counsel for the civil registrar, Your
So
Honor.
is it your position that paragraph 1 is the statutory basis for your participating in divorce proceedings in courts?
I believe so, Your Honor, which could be also the basis for what the Supreme Court issued.
Yes, but as far as I know, from 1987, when the admin code was passed, all the way to 2010, and I think this was admitted to me by your Assistant Solicitor Generals, the Office of the Solicitor General never appeared. It was only in the year 2010.
Yes, Your Honor.
So the OSG has been in dereliction of its duty from 1987 to 2010?
Maybe the OSG was waiting for an instruction from the Supreme Court, Your Honor.
Or maybe the basis for the OSG's appearance is not the admin code, but rather the case of Santo Tomas.
Yes, Your Honor, that's also the first time that the responsibility to appear in such cases was mentioned in that case.
So prior to that, there was never any mandate to appear, correct?
Not expressly, Your Honor, because in the broad spectrum, I believe that the basis will be, again, to represent the position of the Republic with regard to the constitutional provisions on marriage.
Okay. In Corpus versus Santo Tomas and Fujiki versus Marinay, the court ruled that the recognition of a foreign divorce may be made in a Rule 108 proceeding because it supposedly involves the cancellation of the entry of the prior marriage in the records of the civil registry. My question is, does Rule 108 require the OSG to participate in the proceedings?
Yes, Your Honor.
Really?
We are required to participate in the proceedings, Your Honor.
Of Rule 108?
Rule 108, Your Honor.
And what's your basis for this?
Yeah, all special proceedings, Your Honor, the OSG appears in paragraph 1, all special proceedings, Your Honor.
Where?
In the paragraph 1 that we read a while ago, Your Honor.
In which the government or any officer thereof in his official capacity is a party. Who is the government official in a Rule 108 proceeding?
The civil registrar, Your Honor. The civil register.
You always represent the
Yes.
office?
Yes, Your Honor.
Do you have another counsel of record aside from the OSG?
No, Your Honor.
It's only the OSG?
Yes, Your Honor.
Okay. Let me go back to Orbisido. I suppose prior to this oral arguments you read up again, correct?
Yes, Your Honor.
Okay. The court there did not rule that there is a need for a prior petition for authority to remarry or declaratory relief before a foreign divorcee can remarry in the Philippines, right?
Yes, Your Honor.
How about the Filipino former spouse? Did the court in Orbisido say that there is a need for such a petition for authority to remarry?
I believe, Your Honor, that in that case, the court said that the Filipino spouse should be allowed to remarry.
Yes. Was there any express ruling in Orbisido which required that the prior judicial recognition of a foreign divorce must first be obtained before the Filipino spouse under 26(2) can have the capacity to remarry?
No, Your Honor.
Regarding capacity to remarry, this is governed by the family code, right?
Yes, Your Honor.
Okay, just to refresh everybody's memory, I'm flashing again Article 26(2). Where a marriage between is validly set up and a divorce is thereafter validly obtained abroad by the alien spouse, capacitating him or her to remarry, the Filipino spouse shall have capacity to remarry under Philippine law. There is nothing there that talks about a judicial recognition of the foreign divorce before the Filipino spouse can remarry, correct?
Correct, Your Honor.
In fact, under Article 13 of the Family Code, all that is required from the divorcee applicant is that he submits a copy of the judicial decree of absolute divorce to the local civil registrar to obtain a marriage license, correct? I'm flashing Article 13.
Yes, Your Honor.
So the requirement in Orbisido that he must still prove the foreign law, that he must still prove the naturalization of his wife, and his wife's remarriage, they're not required under the family code before a marriage license may be issued by the local civil registrar, correct?
Yes, that's correct, Your Honor.
Okay. So in hindsight, had Orbisido gone straight to the LCR and applied for a marriage license, he would not have been required to prove anything, correct? He would have been given his marriage license, correct?
Yes, Your Honor.
Let's go to Corpus versus Santo Tomas, okay? In this case, Corpus was a Filipino who became a Canadian, and when as a Canadian, he married a Filipina named Santo Tomas. He married in the Philippines. They later obtained a divorce in Canada, and then Corpus went to the LCR Pasig City to register the foreign divorce because he wanted to marry another Filipina. The LCR registered the foreign divorce, but an official from NSO advised him that he must still have the foreign divorce recognized by a Philippine court for it to be enforceable. So what did he do? He filed in the RTC a petition for the recognition of the foreign divorce. And the RTC rendered a decision denying the petition on the ground that Corpus was a Canadian citizen and did not fall under Article 26(2). So to the OSG, do you agree with me that the main issue in Corpus was whether or not 26(2) of the Family Code was available to Corpus, who was already a Canadian? That was the issue, correct?
Yes, Your Honor.
And the court ruled that Corpus did not have the legal interest to seek judicial recognition precisely because he was already a Canadian, correct?
Yes, Your Honor.
In other words, Corpus held that 26(2) is for the benefit of Filipinos. They are not for the benefit of foreigners, correct?
Yes, Your Honor.
Yes. And yet, the court in Corpus said so many other things because it could have stopped there. It said that 26(2), while it did not grant Corpus the right to have the foreign divorce recognized, the court still ruled that Corpus had a legal interest to have it recognized under Rule 39, Section 48B, correct?
Yes, Your Honor.
So this was the attempt of the Supreme Court in Corpus to find a relief for Corpus, correct?
Yes, Your Honor.
And the Supreme Court in Corpus reached that position that we can clothe him with personality or legal interest, and that was his only intention for the discussion on Rule 39, Section 48. Correct?
Yes, Your Honor.
So again, much like in Orbicido, in hindsight, when the trial court said that Mr. Corpus had no standing to file such a petition, Mr. Corpus could simply have abandoned that case and applied for a marriage license because he was a Canadian citizen. Correct? Mr.
Your Honor,
Consul General.
it would have been the case, Your Honor, if not for Orbicido.
If not for Orbicido.
Yes, Your Honor.
Okay. I'm reading Corpus, and I don't find the court saying there that it is a requirement that all foreigners seeking to remarry in the Philippines are required to file a petition for judicial recognition of divorce before they can remarry in the Philippines. Do you agree with my reading?
Your Honor, can you repeat, please?
I am reading Corpus as saying that it did not make it a requirement that all foreigners seeking to remarry in the Philippines are required to file a petition for judicial recognition, because what it essentially did was, it essentially said, Corpus, you're not entitled to 26(2), but we want to give you some form of relief. So maybe that form of relief is in Section 48 of Rule 39. But there was no declaration by the court there that in order to remarry, he needed a judicial recognition of his divorce.
My understanding, Your Honor, is that that was the suggestion and that was the conclusion, Your Honor.
Yes, but that was not the ratio.
No, Your Honor.
All right. In the same Corpus case, in the court's attempt to give legal interest to Mr. Corpus to still find a relief, the court ruled that the local civil registrar of Pasig erred in annotating the Canadian divorce decree on the marriage certificate of Corpus in Santo Tomas. According to the court, the divorce decree must first be judicially recognized by a Philippine court before the same can be registered in the civil registry. I want to dissect the court's ruling on this aspect. So, Mr. Civil Registrar General, first, The premise of the corpus court is that the foreign divorce must first be annotated on corpuses and Santo Tomas marriage certificate before corpus can obtain a marriage license and to remarry. My question is, when a divorcee applies for a marriage license with the local civil registrar, is there any law that requires the local civil registrar to first annotate the divorce decree on the divorcee's marriage certificate covering the now dissolved marriage?
There's no specific law, but there are issuances pursuant to...
Issuances by whom?
Issuances by the Civil Registrar General, the
On the
NSO,
basis
and the
of?
PSC. On the basis of the principle of maintaining the integrity of civil registry records, Your Honor.
Or on the basis of Orbicido and Santo Tomas?
That's also one of the bases, Your Honor.
Because I'm looking at Article 13, and all that it requires is to submit the judicial decree of absolute divorce. That's all. So, for purposes of the court, can you submit to the court within 10 days or 15 days those issuances that you're referring to as still requiring the annotation of the divorce decree on the divorcee's marriage certificate? Can you give me those issuances?
We will submit, Your Honor.
I'm not familiar with them. Okay. But this should not be a basis to deny the marriage license, correct?
Yes, Your Honor.
You will still issue the marriage license, correct?
Yes, Your Honor.
That's under Article 18 of the Civil Code, of the Family Code, correct?
Yes, Your Honor.
All right. Second, the Corpus Court also discussed Article 407 of the Civil Code and Sections 1 and 4 of Act Number 3753, or the Law on Registry of Civil Status. Can we flash that? Acts, events, Article 407, acts, events, and judicial decrees concerning the civil status of persons shall be recorded in the Civil Register. Mr. Civil Service General, Civil Registrar General, a divorce decree is a vital event that affects the status of a person, correct?
Yes, Your Honor.
Those are the vital events under Section 1. And
Yes.
all these provisions on the screen say that the divorce decree must be recorded in the Civil Register, correct?
Yes, Your Honor.
But these provisions are not concerned with the issuance of a marriage license, right?
Yes.
Yes. Because the law that governs the requirements for the issuance of a marriage license is the Family Code, correct?
Yes, Your Honor.
Okay. All right. The Corpus Court also referred to Section 48B, Rule 39. Can we flash that on the screen? Madam Solgen,
Yes,
do
Your
you
Honor.
agree with me that this provision talks about the effect of a foreign judgment in the Philippines?
Yes, Your Honor.
And that this rule is located, that this is located under Rule 39, which talks about execution, satisfaction, and effects of judgments, correct?
Correct, Your Honor.
All right. I'd like to break down this provision in the context of petitioner's foreign divorce. Can we flash the divorce decree of Petitioner Baluyot on the screen? Okay. Let us go to the divorce decree attached as Annex B of Mr. Baluyot's petition with the RTC dated August 11, 2020. It's there on the screen. Do you confirm that this is a form that is filled up by the court issuing the divorce decree?
I would, yes, Your Honor.
By the Superior Court of California.
I assume, Your Honor.
On page 1, shown on the screen, the tick boxes only indicate, first, that the judgment is for dissolution of marriage. Second, that it's a default judgment under Family Code Section 2336. Third, that the respondent was served with process. Fourth, that the judgment of dissolution was entered and that the marital partnership was terminated on October 18, 2010. Can you confirm that that's what that page says?
Yes, Your Honor.
All right. This is going to be a bit tedious. I hope you bear with me. Let's go to page 2, or Annex B1. All right. This shows the following. First, the children are Christian and Melina Baluyot. Second, the boxes for child custody and visitation order attachment are ticked off per Form FL-341. Third, the boxes for child support information and order attachment is ticked off per Form FL-342. Fourth, the box for spousal, partner, or family support order attachment is ticked off per Form FL-343. Fifth, the box for property order attachment to judgment is ticked off per Form FL-345. So they're all tick boxes.
Yes, Your Honor.
All right, let's go to page 3. Annex B2. This is the Child Custody and Visitation Order Attachment Form, or FL-341. Except for the names of the children, no box has been ticked off, correct?
Yes, Your Honor.
Let's go to page 4, or Annex B3. This appears to be a continuation of FL-341. The box for others is ticked off and contains the statement, and I quote, "The jurisdiction of the court on the issue of custody and visitation is reserved since the minor children, Christian A. Baluyot and Melina Marie A. Baluyot, are in the Philippines and outside the jurisdiction of the court." Can you confirm that?
Yes, Your Honor.
Okay. Let's go to page 5, Annex B4. This is the Child Support Information and Order Attachment, or FL-342. Except for the names of the children, no box has been ticked off, correct?
Yes, Your Honor.
Let's go to page 6, Annex B5, which appears to be a continuation of FL-342. Again, no boxes are ticked off except for others, where a statement is found that says, and I quote, "The jurisdiction of the court on the issue of child support is reserved since the minor children, Christian A. Baluyot and Melina Marie A. Baluyot, are in the Philippines and outside the jurisdiction of the court." Agree?
Yes, Your Honor.
Okay, let's go to page 7, Annex B6. This refers to spousal, partner, or family support order attachment, or FL-343. Do you confirm that no box has been ticked off?
Only the box on judgment, Your Honor.
Yes. There is?
Spousal judgment.
Yes. Okay, let's go to page 8, Annex B7, which is a continuation of FL-343. The only box that is ticked off says, and I quote, "The court terminates jurisdiction over the issue of spousal or partner support for the petitioner and respondent." Close quote. Agree?
Yes, Your Honor.
Let's go to page 9. This refers to property order attachment to judgment, or FL-345. The only boxes that have been ticked off say, and I quote, "There are no community property assets," close quote, and at the bottom, quote, "There are no community debts," close quote. Agree?
Yes, Your Honor.
Okay, let's go to page 10, which is a continuation of FL-345. No boxes have been ticked off, correct?
Yes, Your Honor.
All right, let's go to page 11. This appears to be the Notice of Entry of Judgment, or FL-190. And the entry of judgment says that, quote, "You are notified that the following judgment was entered on October 18, 2010, close quote, and the only box that has been ticked off is, quote, "dissolution," close quote." Agree?
Yes, Your Honor.
So it appears to me, having gone through all the pages, that the only matter declared in the foreign divorce is the dissolution of Mr. Baluyot's marriage. Correct?
Yes, Your Honor.
There is no order on support, correct?
None, Your Honor.
There is no order on custody, correct?
Correct, Your Honor.
There is no order on property, correct?
Correct, Your Honor.
So, going back to the language of Rule 39, which concerns, and I quote, execution, satisfaction, and effect of judgments, close quote, what exactly in the divorce decree will be executed and satisfied?
The dissolution, generally, Your Honor, the dissolution. But I
That's
would...
the execution of the judgment.
Yes, Your Honor. Generally,
Okay.
that.
How do you execute the dissolution of the marriage?
Well, for this case, Your Honor, it is our position that because there is an earlier entry in the civil register of the previous marriage, and in order for that entry to be erased or replaced, then...
Or amended?
Then Article 412 of the Civil Code will be applicable, which says that no entry in a civil register shall be changed or corrected without a judicial order.
All right. I will go to 412 in a while. But that is your answer.
Yes, Your Honor.
So you're saying that Rule 39, Section 48 still applies?
Yes, Your Honor. Generally, yes.
The Corpus Court also referred to DOJ Opinion Number 181, Series of 1982, and NSO Circular Number 4, Series of 1982. Have you read those issuances?
No, Your Honor.
Mr. Consul General?
Yes, Your Honor.
All right. The NSO Circular cites the DOJ opinion rendered by Minister of Justice Ricardo Puno. Agree?
Yes, Your Honor.
In essence, per the DOJ opinion, a foreign divorce is merely presumptive evidence of a right between the parties and is not executory in the Philippines until it is judicially recognized by a Philippine court. And the DOJ opinion cites Section 39, Rule 39, Section 50, which is now Rule 39, Section 48. Do you agree that that was the basis of the DOJ opinion?
Yes, Your Honor.
And the DOJ opinion also cites the case of Perkins versus Benguet Consolidated Mining, a case written in Spanish by Justice Pablo. Did you read that case?
I haven't read the case, Your Honor.
Neither did I. It's in Spanish. But from the title, we can see that it did not involve a foreign divorce, did it?
Yes, Your Honor.
Yes. My question now to the OSG, is the DOJ opinion a law?
No, Your Honor.
What about the NSO circular? Is that a law?
No, Your Honor.
So when the NSO circular and the DOJ opinion require prior judicial recognition, didn't these issuances in effect amend the family code, which do not prescribe such requirements?
Your Honor, well,
you don't have to defend the DOJ, you know.
Yes, Your Honor, but I'm surmising that even like this court came to that conclusion from the statutory provisions and therefore came up with provisions also under the rules of court given the provisions under the civil code. So it is
okay. So
not,
let's eliminate them one by one.
Conclusive.
Section 48, Rule 39 is a rule of court, correct?
Yes, Your Honor.
We can change that, correct?
Yes, Your Honor.
Or at least clarify it, that it does not affect foreign divorces, correct?
Yes, Your Honor.
We can do that.
Yes, Your Honor.
I mean, you're not going to object to that, are you? As a tribune of the people.
No, Your Honor.
So the only remaining thing we're talking about is really Article 412 New Civil Code.
Yes, Your Honor.
Which was also mentioned in the Corpus case, correct?
Yes, Your Honor.
All right, can we flash 412? No entry in a civil register shall be changed or corrected without a judicial order. Please stay there. Huh? So to the Solgen, put proper context for this discussion. Let us say that there is a mixed marriage between a Filipina and a foreigner whose marriage is registered with the local civil registrar. They later obtain a foreign divorce abroad, and one of them seeks to remarry in the Philippines. Yun ang facts natin. So, parang bar exams to. Is it the OSG's, just to be clear, is it the OSG's position that Article 412 requires the divorcee to first obtain prior judicial recognition of the foreign divorce before the divorcee may be able to obtain a marriage license in the Philippines?
Under the family code, no, Your Honor.
But under corpus,
Under corpus,
it seems to be yes.
well, it will be harmonized with the family code, and I think that's the specific example that's being contemplated under the exception, Your Honor.
Okay, let's focus on 412. It speaks of a change or a correction in any entry in the civil register. Correction implies that there was an error in an entry, is that correct?
Yes, Your Honor.
Change does not involve an error, as the change can be something simply desired by the person as allowed by law, like change of name, correct?
Yes, Your Honor.
And do you agree that whether it be a change or a correction, what is involved is the modification of an existing entry in the civil register, correct?
Yes, Your Honor.
So in the context of the earlier example involving a divorcee wanting to remarry, the relevant civil entries involved here are the ones involving the prior marriage of the divorcee in the records of the local civil register, correct?
Yes, Your Honor.
Okay. So I want to understand what entries are being contemplated by Article 412. When a marriage is registered with the local civil register, what is being presented for registration is the marriage certificate, correct?
Yes, Your Honor.
So, civil registrar, when the marriage certificate is accepted, is my understanding correct that the LCR or the local civil registrar will enter the details of the document in a book called the marriage register?
Yes, Your Honor.
All right. And the local civil registrar will also keep the original marriage certificate, is that correct?
Yes, Your Honor.
Yes. Am I correct that the details entered in the marriage register are only limited to the names of the parties, the date it was accepted for registration, the date of the marriage, and the assignment of a registry number which will also be stamped on the marriage certificate? Yun lang, di ba?
Yes, Your Honor.
Okay. I myself, I have a sample of a register of court decrees, but I do not have a sample of a marriage register. Are they similar?
It's not similar, Your Honor, but we can submit so that
Yes,
the
please.
court can.
So, can you submit to the court a photocopy of the cover page of the marriage register and a page or two of its contents showing the titles of the entries? You can redact any information.
Yes, Your Honor, we will
Thank
submit.
you. So, to be clear, at that point, there are two official records of the marriage. The first record would be the entries in the marriage register, and the second is the actual certificate of marriage, correct?
Yes, Your Honor.
Can we flash on the screen a sample certificate of marriage? Obviously, ako nagkasal dito kasi pirma ko yun nandyan, ano? But that is a sample of a certificate of marriage. So it contains several entries such as names, birth dates, sexes, citizenships, place of marriage, date of marriage, among other things, correct?
Yes, Your Honor.
So for the record, can I ask the Solgen to confirm that these are the entries in the certificate of marriage?
I confirm, Your Honor.
Okay. So now, Civil Registrar General, if we follow the theory of the OSG, that Article 412 applies to a divorcee who wants to remarry, what particular entry in the marriage register or in the certificate of marriage would have to be changed?
It would be the specific entry, Your Honor, in the registry book.
But not in the marriage certificate.
Not in the marriage certificate, Your Honor.
And what will it say? What will it say in that book?
It will have a remark, a note there, Your Honor, that by virtue of a decision, the marriage is terminated or dissolved.
But there is nothing in the certificate of marriage that is changed, correct? There's no entry.
There will be no entry that will be changed here.
And there is no entry there that will be corrected, correct?
Yes, Your Honor.
So to be clear, okay, hold on. Okay. So to be clear, is it the OSG's position that any change in marital status in the records of the LCR can only be done through a court order?
Yes, Your Honor, except for innocuous and harmless entries, which the Congress enacted RA number 9048 to exempt the clerical errors from the requirement of a judicial proceeding.
Let me rephrase my question. When a married person's spouse dies, the marriage is terminated, correct?
Yes, Your Honor.
So death is an event that changes the surviving spouse civil status from married to single, correct?
Yes, Your Honor.
With that change in civil status, the surviving spouse may then immediately apply for a marriage license and remarry, correct? That's Article 13, Family Code.
Yes, Your Honor.
Okay. It says, it provides that when a party was previously married, he or she just has to furnish, quote, the death certificate of the deceased spouse or the judicial decree of absolute divorce, correct?
Yes, Your Honor.
So do you agree with me that the surviving spouse does not have to go to court to first obtain a court order to recognize the death of the deceased spouse and to pray for a change in the marriage register or the certificate of marriage to indicate that the surviving spouse is now single, right? I don't need a judicial order saying that my spouse is dead.
Yes, Your Honor. The death certificate, in fact, is required to be entered as well into the register.
So the death of the spouse is an event that changes one's status, but it does not require a court order, correct?
Correct, Your Honor.
Let me also go to another example. Republic Act 9255, which amends Article 176 of the Family Code. This is an illegitimate child wanting to use the surname of the father. Let me ask the Civil Registry General, when an illegitimate child presents to the local civil register an affidavit of acknowledgement or affidavit of admission of paternity executed by the father, may the local civil registrar register the same even without a court order?
Yes, Your Honor.
Yes. Can you bring up Act number 3753, IRR Rule 64? So when the affidavit of acknowledgement or admission of paternity is sent to the local civil registrar and is registered by the local civil registrar, is my understanding correct that the LCR will not change any existing entry in the child's birth certificate? He will not change anything in the birth certificate, correct? He will simply make an annotation.
Yes, Your Honor.
He will make an annotation on the birth certificate referencing the affidavit, correct?
Yes, Your Honor.
In fact, that's what paragraphs 2 and 3 talk about. Do you agree? That's what the LCR is supposed to do. Shall
Yes, Your
not
Honor.
be erased or deleted.
Yes, Your Honor.
Now, my question to the Solgen, is it your position that an illegitimate child seeking to use the surname of the father on the basis of the said affidavit should first obtain a court order before the affidavit may be registered with the LCR?
No, Your Honor, because the provision says that if there is a change or correction, so rather than like a death is entered also in the civil register, and it's not meant to
So no need for a court
supplant
order.
the birth.
My only question is, there's no need for a court order.
No, Your Honor.
All right. Let me go to another example. Republic Act number 9858, amending Article 177 of the Family Code. This is legitimation. Children conceived and born outside of wedlock of parents who at the time of conception were not disqualified by any impediment to marry each other. That's Article 177. Let me ask you, Mr. General. I'll just call you Mr. General. Okay lang yan? You're also a general. Oh my God. Civil Registry General. In the case of legitimation, is my understanding correct that the local civil registrar only requires an affidavit of legitimation narrating the relevant facts together with supporting documents as the birth certificate of the child and the marriage certificate of the parents? That's all?
Yes, Your Honor.
It does not require any court order, right?
Yes, Your Honor.
So when the local civil registrar registers the affidavit of legitimation, am I also correct that there will be no change of any entry in the child's birth certificate? And that the local civil registrar will simply make an annotation on the birth certificate referencing the affidavit?
That's correct, Your Honor.
All right. For the record, I will ask this of the Solicitor General. Is it your position that for a child to be able to reflect his status as legitimated with the local civil registrar, he or she should first obtain a court order before the affidavit of legitimation may be registered with the LCR?
No, Your Honor.
All right. So in both of these examples of the use of father's surname and legitimation, they do not involve any change in any of the entries in a child's birth certificate. Therefore, will you agree with me, Madam Solicitor General, that since no entries are changed or corrected, then Article 412 does not come into play?
What we believe, Your Honor, is that the change in the status, which affects the legal capacity, is being changed because of the earlier entry of Mr. Baluyot here. And
Aside from the cases in divorce that we are talking about, do you have any other basis to say that? That is actually covered? Because my simple example is, pag namatay ang asawa mo, you don't need a court order. So 412 is not even triggered.
But for death, Your Honor, it is also required to be registered in the civil register.
Yes, but you don't need the court order.
Yes, because another statute says that it is required to be entered, and therefore, this, like 9048, which is an exception, which is a statute, it also does not need to go under a judicial order because the legislature has accepted
Exactly my point. So you don't need a court order.
Yes, Your Honor.
All right. Okay, let's talk about examples of surname and examples that involve court judgments. I want to know more on how a court judgment affecting civil status is registered. So when a Philippine court annuls or declares as void a marriage, is my understanding correct that the judgment is merely annotated on the marriage certificate without changing any particular entry in the marriage certificate?
Yes, Your Honor.
Can you flash a sample? That's a sample. So the marriage certificate itself is not canceled, correct?
Yes, Your Honor.
All right. In the case of a foreign divorce decree that has been judicially recognized in the Philippines, is my understanding correct that the local civil registrar will merely annotate the Philippine decision on the marriage certificate without changing or canceling any existing entry in the marriage certificate?
Yes, Your Honor.
Okay. Can you flash again an example of that? Like I said, I was the one who married this couple. Is that how a foreign divorce is annotated?
Yes, Your Honor.
As in, so no existing entry in the marriage certificate is changed, correct?
Yes, Your Honor.
No existing entry in the marriage certificate is corrected, correct?
Yes, Your Honor.
All right. All right. Since I've already covered Orbicido and Corpus, can I ask the Solgen, is there anything to stop the current court in today's wisdom, in today's recognition of access to justice, from abandoning two division cases that seem to require judicial recognition for purposes of issuance of a marriage license? Is there anything stopping us by law?
Just for the recognition of,
That I need.
generally, Your Honor, no, but sorry, because I could not put into context by referring to the case at hand, Your Honor, and our position is that under Article 17, because it is the position of the Republic that absolute divorce is against public policy, that it is in fact a right of the sovereign state not to recognize a foreign judgment that is against its public policy,
All right.
Your Honor.
So aside from a public policy premise, we can change it if we think it's wrong, right?
Your Honor, if we think it's wrong, yes, we have that discretion to explore the parameters. It's just that our reservation is we have discussed a lot of processes on the side of the civil register, and we have also, and all of them are also based on their issuances. And
No, hold on. Everything is so convoluted already.
yes, they
Precisely because of their issuances, which are based on two division cases rendered in 2005 and 2010. So, sobrang buhol-buhol na lahat. I'd like to take the option of Alexander the Great. Instead of untangling this knot, why don't we just cut it off? That's what I'm exploring.
Yes, Your Honor. So we are also anticipating a regime where we have 9048 applied to other cases so that it will be summary and it will not...
Sorry, what's 9048?
It is the exception. RA 9048 exempts the clerical errors from the requirement of a judicial proceeding under Article 412. So this is the...
Yes, but I guess everything that can be put into the cauldron to solve a problem that's denying so many people access to justice, we can talk about. But as far as the requirements set by Orbicido and Corpus being requirements set by divisions only of the Supreme Court almost 20 years ago.
Yes, Your Honor. So we agree with your tracing of the cases, where it came from. Is it a conclusion of the court, and therefore those that are not based on law can very much be changed by this court, Your Honor.
Except now you're telling me public policy.
Yes, Your Honor.
All right, let's talk about public policy. Okay. You're citing Article 2, Section 12, Article 15, Section 1, Article 15, Section 2 of the Constitution as evincing a public policy against divorce. Are you saying that these constitutional policies would be violated by recognizing a foreign divorce decree obtained by a Filipino spouse?
No, Your Honor. I'm referring to the public policy of two Filipinos who obtain a divorce.
Now I'm talking about a mixed marriage.
No, Your Honor, because that's the narrow exception carved out by our statutes.
And therefore, that narrow exception is not prohibited by the constitutional provisions you narrated in your memorandum.
Yes, Your Honor.
Let's be clear about that, because I understood that you're invoking these provisions as saying that divorce cannot be passed here in the Philippines.
It is, I am not saying, Your Honor, that divorce cannot be passed here.
No, you're saying that these provisions evince a public policy against divorce.
Against absolute divorce, Your Honor.
And between a law and a constitution, mauuna yung constitution.
I would like to emphasize that the public policy is against against absolute divorce, and in fact, our laws acknowledge or allow or provide for a legal mechanism for relative divorce. Your
You're
Honor.
talking about 26-2.
26-2,
But two Filipinos wanting to
annulment.
get divorced.
No, Your Honor.
All the pending bills in Congress, they're unconstitutional.
No, Your Honor. So by public policy, and public policy can change.
Exactly my point.
Yes, Your Honor.
So the pending legislation now advocating for divorce between two Filipinos, would they be unconstitutional in your view?
No, Your Honor. In determining or ascertaining what is the public policy, it is a holistic view based on the Constitution, based on the statutes and the actions also of our legislature. The basis of the Republic is that there have been pending bills, divorce bills, and their inaction
Evinces public policy?
express that it is their
Parang
position now.
I can't seem to accept that failure to pass the law evinces a public policy against those laws. What if they get passed?
Then the legislature or the political branches are the primary branches that determine what is the public policy, Your Honor.
What about the Code of Muslim Personal Laws, PD 1083? Is that unconstitutional?
No, Your Honor. There has been also a case with regard to that, and
But it goes against the constitutional provisions you've been citing in your memorandum, right?
yes, Your Honor. But the customs, traditions of the Muslims have been respected, and they are also in
I don't think
our
you can have it
Constitution.
both ways, you know? It's either unconstitutional or it's not. By your reasoning, I don't think you can cut it both ways.
Well, every hard case, Your Honor, sometimes stretches the court to apply or to discern what is equitable or what is fair.
All right.
in-
On that note, can you flash the Republic versus Manalo? This is an en banc case penned by former Chief Justice Peralta. Can you flash it? The one on top of it. Manalo cites the exchange in the deliberations of the Constitution. Can we flash that? This was cited in the case of Republic versus Manalo, and to be like Justice De Mampao, it's GR number 221029. April 24, 2018. I don't know the page. Yeah, the other one, the one you posted, the one there. That's the language of Chief Justice Peralta. The 1987 Constitution expresses that marriage, nevertheless, it was not meant to be a general prohibition on divorce. And then he cites the deliberations in the Constitutional Convention. And Father Bernas says, my question is more categorical. Does this carry the meaning of prohibiting a divorce law? And Chito Gascon says, no, Mr. Presiding Officer. So I guess the OSG follows cases rendered by the court en banc as part of the law of the land, right?
Yes, Your Honor.
And therefore, it will recognize any divorce law that is passed by Congress, given the declaration of the Supreme Court en banc.
No, Your Honor.
I'm not trying to catch you in a bind. We're all on the same boat here. Let me say that for the record. The way I'm seeing all of these issues, they're also convoluted. And then the challenge to us now is to find, how do we simplify? Because we say 26.2 is the solution, and yet it is not. Because everything that happens on the ground prevents a normal Filipina married to a Japanese from getting a divorce. And she has to incur the costs and the expenses of time just to file a petition and then have that appealed by the OSG all the way to the Supreme Court. We're talking years. So 26.2 is an illusion if that's the case. And that is why the challenge, I think, for this court in this case is precisely to find, with the assistance of the Solgen, a legal solution to cutting the Gordian's knot. That's where I'm coming from.
Your Honor, we share your struggle, and as a small contribution, we have also been more discerning in the appeal of cases that have been granted in regard to annulment or petition for nullity, which used to be generally, it has been
straightforward
appealed.
under the Civil Code. Has now become so convoluted because of Orbecido and Santo Tomas. With all of these requirements that effectively say 26.2 is an illusion.
But I think the court also expanded and helped many Filipinos as well in the Orbecido case, because it stretched, it extended the reckoning moment to the time of divorce.
Okay. Mr. Consul General, you can sit down. Thank you for answering all my questions. Can I ask Amici Mel, do you mind if you answer my questions in tandem with the Solgen? I don't know if in tandem, no, pero together with.
Yes, Your Honor.
Okay.
Okay.
So to the Solicitor General, the nationality principle is Article 15 Civil Code, right?
Yes, Your Honor.
In the context of family law, this means that the family code applies to Filipinos even though abroad, correct?
Yes, Your Honor.
So let's have another example. Today is a day of examples for me. So two Filipinos who married each other here in the Philippines and later migrated to the United States. Do you agree with me that their divorce in the U.S. because of Article 15 is ineffectual or void because of the nationality principle?
Yes, Your Honor.
Because they're both Filipinos.
Yes, Your Honor.
Do you have any issues with that, Mr. Santamaria?
Yes, Your Honor, I have an issue on that, Your Honor. If we follow the 1939 Sicat versus Cancion case, and if we follow the Tenchabes case in 1964, probably that is the correct answer. But these are public policy judicial statements made long time ago.
But Article 15 is still here.
Article 15, Your Honor, if you look closely at Article 15, as I was saying a while ago, it merely defines the legal identity of a person, its attributes and nuances, but it does not prohibit a change of status. It does not prohibit a change of status.
All right.
So that if you relate that to Rule 39, Section 48. If you join them together, Your Honor, one is the coming in and the other is the going out. Article 15 will say, okay, if you have changed status by way of Rule 39, we will protect you of that change in status, because we change in status, we change status all the time. As you have said a while ago, married person, namatay, single. Legitimate, legitimated. Stranger child, adopted child. We do it all the time. So therefore, Article 15 does not prohibit a change of status, Your Honor.
Okay. Can we remain with my example? The two Filipinos married each other in the Philippines, and they later migrate. If they divorce in the US and they're still Filipinos, it's void per Solgen. Mr. Santamaria has issues with that. Okay.
Yes.
Supposing they become naturalized Americans before obtaining their divorce. At that point in time, do you agree with me that Philippine law no longer sees them as Filipinos?
Yes, Your Honor.
In fact, the family code no longer applies to them.
Yes, Your Honor. If they are both naturalized before getting divorced.
Yes,
Your Honor.
but for the Solicitor General,
Both of them,
become naturalized Americans.
yes, Your Honor.
So Article 15 no longer applies, family code no longer applies. So when they get divorced after naturalization, it will be a situation of two Americans divorcing each other, correct?
Yes, Your Honor.
No different from two white Caucasian Americans divorcing each other. No different.
Yes, Your Honor.
And Philippine law will not have a problem with that, right?
Yes, Your Honor.
And if one of them desires to get married in the Philippines to a Filipino, that person who is now an American will be considered as having the requisite capacity to remarry, correct?
Yes, Your Honor.
All right. Let's change the example again. Supposing, or let's suppose that they become naturalized citizens of America after obtaining the divorce. So, Pilipino sila, they divorced, and then they become citizens. My question is this: what is the current law governing their capacity to marry? Isn't it U.S. law? They're Americans already.
Yes, Your Honor. But again, in this case, Your Honor, the framework under our law is that if they were still Filipinos when they divorced, then that is against our public
But
policy.
what eyes are you looking? What eyes are you using? The two of them are now American citizens. They're now American.
Yes, Your Honor.
Therefore, I recognize that their national laws are U.S. laws.
Yes, Your Honor.
Your Honor, so the
We're climbing into a time machine all the time.
Yes, Your Honor.
right, Your Honor. So your situation, Your Honor, they're both Filipinos at the time of the divorce, and then thereafter they changed their citizenship
Yes.
to Americans, Your Honor.
Yes.
Well, Your Honor, citizenship does not change status, Your Honor. If we still consider the old law that divorce is void, that divorce cannot be recognized in the Philippines because they were both Filipinos at the time.
That's
they
the
attained
position of the
divorce.
Soldier now.
Yes, yes. If we follow the old rule, Your Honor, the subsequent change in citizenship will not change the situation, Your Honor. Will not change the situation, Your Honor. That,
No. He's applying for a marriage license here now.
After obtaining
The
American
divorce.
citizenship.
Yes. Now he's coming here because he wants to marry another Filipina.
That cannot be done, Your Honor, because as I've said...
But
the
he's an
citi-
American.
He's an American, yes, he's an American, but at the time he was...
Does it matter? He's an American right now, applying for a marriage license. And I look at him as an American. And therefore, I look at his personal laws as American. Why am I climbing into a time machine to go back 30 years earlier to find out what he did as a Filipino? I don't get it.
Well, That's correct, Your Honor. I agree with you, Your Honor. It's really a convoluted thing, but I think your position is more tenable, Your Honor.
Thank you, Mr. Zanoni. No, let me call your attention to Article 16 of the Civil Code.
Yeah.
That's the situation of a Filipino who becomes a foreigner and he dies. Article 16 says that the operative law for succession is his national law. And what is the national law at time of death? US law na yan.
Yes. Yeah. That's straightforward, Your Honor.
So whatever properties he leaves in the Philippines is governed by US law.
That's
So
straightforward, Your Honor.
why is marriage so different?
Your Honor, so that you will also thank me, I see your wisdom.
We see your point, Your Honor.
We see very much your point, Your Honor. It's just that when these cases, and especially this case, is a hard case.
I know.
And the law does not anticipate all cases that can happen, especially with the globalization. And in fact, the modern trend is not nationality, not domicile, but habitual residence. However, judges, when we file our cases in the trial court, will be referring to our statutes, to our constitution.
Yeah, I'm just situating Article 15 where it should properly be situated. It is properly situated in a situation where two Filipinos get divorced abroad, and if you ask the question, is that valid? No, it's not, because Article 15 still applies. But when those same two people become American citizens, Article 15 doesn't even come to play anymore. And they apply for a license in the Philippines. What eyes will I look at? Will I use? Except for the color of the skin. Amerikano to. And I think that's what the local civil registrar is saying. I will give him the marriage license. He's an American, regardless of what may have happened before. Because at this point in time, ano ka ba?
Your Honor, and that's why I'm referring always that it is very hard to give a generalization for a hard case, because we are looking for what is the most fair and what is the most equitable, but it is our position that the legal framework
I'm not carving out a
You're-
legal framework as an exception. What I'm saying is we have to understand how Article 15 applies.
Your Honor, I realize
Yes.
that you are correct now after evaluating the situation, because as I have said a while ago, Your Honor, the Article 15 only gives the attributes, the nuance of a person. Family rights, duties, condition, status, legal capacity shall be determined by the nationality law of the land everywhere he goes. So if that is not static, that it could change, then you are correct, Your Honor. Because the change is so substantial, from Filipino to American, it does not prohibit a change, and so that at the time the change has already been made, he is already an American, then so be it, Your Honor. You're
Again,
correct.
for the record, I'm not carving out an exception for Mr. Baluyot or people situated like him. I'm trying to properly understand how Article 15 works. Because if I juxtapose that with Article 16, I don't see the difference. Because Article 16 talks about successional rights of the nationality of the deceased. The same manner should be here. At the point of applying for a marriage license, I see him as an American, and therefore his national laws. And I don't climb a time machine to go back and see everything that he did in his life.
Yes, Your Honor. When I was trying to clarify, Your Honor, a while ago, because I think that this is exactly the situation that was being anticipated in the deliberations of the Code Commission, because what if it could also result in a slippery slope where Filipinos who can go abroad, divorce, and then be naturalized.
That's not even a real situation anymore. Everybody, I'm talking about OFWs. They're the ones who have problems. They're always abroad. They remit money to us. and then they fall out of love. And then, you know the story. And then we deny them?
Yes, Your Honor.
You are making it difficult. And for why? Why? Because we have this fascination with this time machine that we have to go back in time?
We are proffering our position, Your Honor. It is, of course, dependent on the wisdom of this court to see the parameters also of the judicial power to interpret.
Okay, I have one last question. For today. Republic Act 9225. Is it the position of the Solgen that Section 5, in using the words attendant liabilities, he is subject to the attendant liabilities in a dual citizenship? Does it mean that Mr. Baluyot's marriage to Ms. Vina is invalid and therefore their children are illegitimate? Is that your position?
Yes, Your Honor.
So the two children of Mr. Baluyot with Ms. Vina who are in the States are illegitimate, while his two children with his first wife, Fe, born in the Philippines, are legitimate. That's what you understand by attendant liabilities.
Yes, Your Honor.
But this law was passed to entice Filipinos to take back their citizenship, right?
Yes, Your Honor.
That's not much of an enticement, is it?
Yes, Your Honor. And,
Na yung anak mo magiging illegitimate.
Yes, Your Honor. And as I mentioned earlier today, in RA 9225, when we were looking at the deliberations, we believe that the aspects on the civil aspects or have not been thought through thoroughly, and that RA 9225 was more based on the political rights and restoring the political rights, and therefore...
But in interpreting it amidst all the laws that we have here, the Supreme Court can interpret it along access to justice principles, right?
Yes, Your Honor.
And therefore recognize the law as an enticement and therefore understand that phrase differently, correct?
Yes, Your Honor.
All right.
For me, Your Honor.
Please.
For me, Your Honor, if we continue with 26.2 and the rule of non-recognition of foreign divorce by Filipinos, Your Honor, it will continue what I call a double existence. It will be a perpetual problem. A double existence, a split-screen existence, a systematic exclusion from the universal singularity of status. Your Honor, parati tayo magkakaroon ng state-mandated schizophrenia, Your Honor. Talagang, and if that is the case, Your Honor, that will be in violation of our constitutional principle that the state values the dignity of all human person and guarantees full respect for human rights, Your Honor. Because, Your Honor, the external legal status of a person must necessarily jibe with his internal self-perception. If you don't do that, Your Honor, he cannot go on with certain activities that will be, like for example, marry again. He will be susceptible to bigamy, adultery, concubinage, etc. And so that therefore, Your Honor, unless we see our Rule 48, Rule 39, Section 48, as a bridge to connect the civil status and the lived experience of the person, we will have this problem perpetually, Your Honor.
But going back to 9225, are we agreed that, as you say, Solicitor General, it focused more on the political rights, not the civil rights, that this is fertile ground now for the court, in its wisdom, to interpret it in a way in accord with what we think is rightfully just?
Yes, Your Honor, in line with...
It's fertile ground, right?
Yes, Your Honor, in line with the principles in the Constitution already on human dignity, on human rights, on the necessity for a mental well-being. So, that's correct, Your Honor.
Your Honor, I think that this honorable court will be beset with a lot of interests and a lot of harmonizing to do. So, but you have the elbow room, you have the space to use your utmost discretion in resolving the pending issues in this case, Your Honor.
All right, thank you very much. Thank you for indulging me. Thank you.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, Justice Ben. We will suspend further interpellation to resume on August 11 at 9:30 a.m. Attorney Marife, other matters?
There are no other matters, Your Honor.
There being no other matters, session is ended.
All rise. Please remain standing while the Chief Justice, the Senior Associate Justice, and the Associate Justices leave the session hall.